when the evidence was availed. I conclude by submitting that what we have before the court is clearly a corrupted, and I'm not talking about a person, I'm talking about the verb, a corrupted and compromised RTS system which does not meet the demands of the Constitution and the Act. And it is only a matter, it is a matter that will be determined after scrutiny whether something can be retrieved from the system, which includes, and we focus on the results that were first uploaded onto the KIMS kits. Perhaps that's where we will find some truth. But whatever got to Bomas of Kenya was totally corrupted, I submit, by corrupt IEBC officials. I lastly point out that you will find in the affidavit of Mr. Benson Wasonga, Smartmatic, by some strange coincidence, is reportedly mired in several controversies in the management of elections technology around the world, including Venezuela and the Philippines. So perhaps that makes them unqualified to most of us, but makes them eminently qualified for the fraudulent objectives of the first and second respondents. Thank you.
I'll help you because I stole your time. No, you didn't. We are well with you. My Lady Chief Justice, my ladies, my lords of the court, I address the court on issues 8 and 9, the magnitude of the matters which you've been listening to and which are set out in all our documents, and I will turn later to the prayers. This morning, in the last 3 of the submissions from my colleagues, the question of what Mr. Chebukati was doing when Article 183 began to operate, 138 began to operate once the 34As moved from the polling stations to the constituency levels to become 34B, and then from there to the National Tallying Center. And Article 138.3 is Article 138 is entitled, the marginal note, Procedure at Presidential Election. And sub-article 3 is, in a presidential election, paragraph C, after counting the votes in the polling stations, the Independent Electoral and Boundaries Commission shall tally and verify the count and declare the result. 138.3c. And so there are 3 steps to be taken after leaving the polling stations. They shall be tallied and verified and the result declared. And the party that is tasked with the duty of doing these three things is, under the Constitution, the Independent Electoral and Boundaries Commission. As you have heard, as you have read all the documents, we saw only Mr. Chebukati doing these duties and not doing these duties as part of the commission, but by himself, together with his clerks, together with his team members, to which I will come in a moment, but not in their capacity as having any decision-making powers over the steps he was taking as the person doing tallying and verifying. Why was there not the Independent Electoral and Boundaries Commission not taking these steps by itself or through itself? And the answer to that is given by Mr. Chebukati himself, and it is in his replying affidavit, sworn on the 26th day of August 2022. And this is what he is setting out in paragraph 108. Sorry, 103. Thank you. On page 10, members of the court, my apologies, to paragraph 37. And this is what Mr. Chebukati says, that the Commission, from Gazette Notice number 9540, number 155, dated 8th of August 2022, a day before the election, outlined the result pathway from the polling station to the national tallying as follows. And then he quotes the Gazette Notice, subtitle, "The Presidential Returning Officer," into brackets, Commission Chairman, Roman 1, receives Form 34As and 34B. Article 138 is reading that the form should be received by the IBC. Roman 2 from the Gazette Notice, the Presidential Returning Officer, Commission Chairperson, verifies. And later on, again, he says, declares. Where does he get this authority from? Is from the Gazette Notice. And so that Gazette Notice is set out in his affidavit. And the Gazette Notice is reading on page 36. This Gazette Notice is in the X made, and it sets out the result paths at the National Tallying Center, which we have seen. And so we search for the authority to move away from Article 138. How did it get from IBC to Mr. Chebukati? In exercise of the powers confirmed by Articles 88, 44 of the Constitution, Section 4 of the IBC Act, Sections 38, 39 of the Elections Act, and Regulations 87(1)(b) of the Elections General Regulations 2012. This shift has come through these General Regulations 2012, which were amended at a different time, and brings a different receiving party. And that receiving party is the returning officer, into brackets, commission chairman, and the 87 itself, the regulation, is an amendment and is referred to by Mr. Chebukati. We submit that Regulation 87 and this pathway that he has put down is a repeat of Article 138(3)(c), but with one significant alteration. Instead of the IBC receiving the votes, instead of the IBC verifying the votes and declaring the tally and the verification, he has put his own name, the chairman. Simple submission we have that this is subsidiary legislation. The pathway which he was relying on in the Gazette notice is void totally. The subsidiary legislation from which the Gazette notice is derived is void, as being in total conflict with not only its principal legislation, but with the Constitution itself. This is what takes the tallying and verification process away from the IBC and took it into what was happening from the 9th of August right up to the 15th of August. And this was breaking every single national value set out in Article 10. The
New sea South Ultra concentrate is packed with 4 times more fragrance.
Understand that there isn't only one check. There is a second key check. From the 34As to the 34Bs, there is generated 34C. And 34C is so key that it needs a second check. And who is there to do that checking? No longer the agents at the polling stations. In their place, the Constitution sets the IBC, the 7 commissioners. And the 7 commissioners are checking the movement of the thousands of 34As into 292 or 290 of the 34Bs. And the people watching them are the 7 commissioners who are representing the people of Kenya, overlooking the process. And by shutting them out, as has been set out by numerous of the affidavits and the television itself, that those 6 were kept away from the process of verification, so that the participation of the people of Kenya over the process of establishing the will of the people was closed down. But there is even a more dangerous thing going on here, and it is this. By this amendment, there was a concentration of the entire process, both of the verification as well as the decision-making as a consequence of that tallying and verification, a concentration into only one individual. And it gave him the power, that Gazette notice, that subsidiary legislation, in violation of the Constitution itself, to take these decisions, and vested in him an asset, a power to find a result all by himself, with no check. And if such a person were an auctioneer, then he had got into his hands, if you want to be a successful auctioneer, you must have something to auction. And this, the supreme prize in our politics, in our national life, in our institutions, had come into the hands of one person. This is a danger so great that it has been the push from the beginning of this election campaign, before the election. Keep your eyes on 34A at the polling station. Anybody who questions anything after that is an agitator, a person who is out to commit violence, is a person seeking this and that and the other. These are all decoys, taking away the key information that one man is doing this, and this petition is the most important petition that we have had. It is from this bench. There are 3 counsel here who filed and were present and argued the first presidential election petition against an incumbent 25 years ago, in 1992, now 30 years ago. And we have had to move step by step, pushing from very crude checking against very crude stuffing of ballot boxes to this day, when our ballot boxes are being stuffed with a highly sophisticated other writing form. And this is not about 2 people, it's not about one person, it's not about political ambition. This is what happens when this chairman is left to do what he has carefully managed to do. And it is therefore our first prayer that this court, the Supreme Court, holds and declares that the Gazette notice and the 87 subsidiary legislation of the general regulations is null and void for being contrary to its principal legislation and constitution. This is why there are people going to people's houses at 3 a.m. and 4 a.m. But is it something so unbelievable? No, this method, how is it that every 5 years, under the chairmanship of this particular officer, we have a crisis? Let me show you another step taken by Mr. Chebukati in this election. On the 8th of August, Mr. Chebukati announced that the gubernatorial elections for the next day in Mombasa and in Kakamega were postponed. And he puts it out in a Gazette notice. Once again, we have queried whether that was a decision of the Commission or of himself. And we asked the reasons. And he has set out the reasons in that same affidavit at page 25. And at page 25, he sets out why he had to do it. Sorry. And this is what he says. Paragraph 103 of that affidavit on page 25, that despite spirited efforts by him and his whole teams, whatever they are, to have the printer replace the ballot papers urgently, it was not possible, he says, to complete all logistics in time for the elections. In the circumstances, the Commission was constrained, now he is seeking their umbrella, was constrained to postpone the gubernatorial elections in Kakamega and Mombasa, and then he gives the authority. Pursuant to Section 55B of the Elections Act and Regulation 64 of the Elections General Regulations, which allows the Commission to postpone an election in a constituency, county, or ward, quote, I've been quoting, quote, where it is impossible for an election to proceed, full stop. Then he says that the postponement was for a limited. So he has set out that it was postponed under these two sections and regulations where it is impossible for an election to proceed. So we look up section 55B of the Elections Act. Here is 55B of the Elections Act. Postponement of elections by the Commission. Section 1. The Commission may, where a date has been appointed for holding an election, postpone the election in a constituency, county, or ward for such period as it may consider necessary, where A, there is reason to believe that a serious breach of peace is likely to occur if an election is held on that date. But Mr. Chebukati says that's not the reason. B, it is impossible to conduct the elections as a result of a natural disaster or other emergencies. He hasn't said it was because of the natural disaster or other emergencies. He doesn't say they were there. C, that there has been occurrence of an electoral malpractice of such a nature and gravity as to make it impossible for an election to proceed. A, B, C. None of these were applicable, but Even if they were invoked, none of them were present in fact. But see what Mr. Chebukati had done. He had lied. He said that in Section 55B, it is provided that they may postpone if it is impossible to conduct the elections, full stop. And when we look at Regulation 67, it's identical with the same conditions. Once again, he is lying. And there is not the slightest concern, for the values of Article 10 and the whole Constitution. This is two things here to watch, members of the court. Number one, that this is a person who is saying these things with impunity. This is a person who sets out the wrongdoing that he is practicing with mens rea. This is not a mistake. This is a very calculated, very calculated subversion of forethought. He plans this, does it on the last day, doesn't explain what those conditions are which make it impossible, and delays it. And then it does not matter to him that at least 2-3 million people in Mombasa County and Kakamega County have been deprived of their right to vote. That it is important and reversing that a presidential election has to be held on the days when the general election is held. This is how the mess that has brought 100, a full Supreme Court, here. Because this man, when you ask him these things, justifies it, knows that it is wrong, and puts it in an affidavit. And then says to us, you explain it. So, it is important not that we cannot rely on a single thing. This is a practiced artist of the destruction of our institutions. Because that is what happens. He did it in 2017. He was caught. When the court ordered him to disclose more things, he disobeyed the order, never did it, and took the benefit of the continued change of circumstances, a new election, etc. And now, back again, he is here. Same person, same sort of tricks. This was in 2012 and 2013, this amendment. This man has been practicing this for 2 election cycles. And he comes here, read this affidavit. Every 2 sentences he says, I'm conscious of the importance of my work as a state organ or a state officer. I'm a practicing advocate, and my professional integrity would never allow me to do these things. I told the NSIS, I am standing up for what is right. I told the 4 commissioners, never, I don't do things like that. When people are running, the person who calls out louder, thief, thief, thief. So that this is what has been going on, and it is destroying our institutions. This case is about the democratic institutions of Kenya. And it is about how we protect those institutions and how we stop people who are attacking those institutions. We cannot do it on the streets. We do it through the institutions. We were doing it through the bar. Now the burden has come to the judiciary because of the new constitution. And we pray that that burden will be borne constantly, persistently, with courage, because when such burdens are not borne, all of us fall down, including courts. And is that something that should be, is that something that has to be spoken to, I mean spoken for, by a party who is seeking justice? And the answer, fortunately, is no. The Constitution itself gives the answer. And that is set out in Article 3(2), which says that it is the duty, every person has an obligation to respect, uphold, and defend this Constitution. Defend? Armies coming from abroad don't care about our Constitution. We're not defending this Constitution against armed incursion from anywhere. That defense is from enemies within who use this type of thing. It is not unusual. The subsidiary legislation emanates, as we all know, from the institution itself. And a letter goes to the Attorney General saying, I would like to amend this. This is what I want. The Attorney General says, give us a draft. The draft comes, sent to the draftsman, legal draftsman. First draft goes to various ministries, Attorney Generals, other departments, public, to the Interior Ministry, la. So this has been done very calculatedly. Very few of us are going to read this to see it, but no one even saw it in 2017. So we have work ahead of us. And so may I turn then to the second issue that I'm coming on to submit to your ladyships and lordships, and that is Sure. Thank you. Sorry, Mary. So the prayers are there. We are asking for prayers in the petition, and we respectfully request that the court looks at them and deliberates on them. But the court also has powers from other places. For example, in the Elections Act itself, under Section 80, subsection 4, the court has power. The court has power to, if there is evidence that you find, you may issue directions that the certificate is to be made out in the name of the person who has secured more votes. The second prayer we do make outside this is this, that we cannot have, whatever the outcome of this petition, we cannot have the self-discredited person who is giving false affidavits and doing all these things to be the chairperson of the IEBC or anything at all. And so we are also saying that there are two prayers in relation to this. The Article 3 of our Constitution says this. Article 3, sub-article 2. And this is at the heart, I pray, of the judgment that this Honourable Court gives. 2. Any attempt to establish a government otherwise than in compliance with this Constitution is unlawful. Any attempt to establish a government otherwise than in compliance with this Constitution is unlawful. And so, in what is a 34C? A 34C is what leads to 34B, which leads to the declaration of a precedent, which is the formation of a new government. That is what was going on the 15th of August there. An attempt, and even here, right now in this court, there are people who have filed things in contravention of the saying that what is in contravention of the Constitution is correct. And right here in this, there is an attempt to establish a government otherwise than in compliance with this Constitution. It's unlawful. So, if this Honourable Court finds that Mr. Chebukati is responsible for and has committed actions and decisions which are an attempt to establish a government otherwise than in compliance with this Constitution, we pray that you make a holding that he has done such an attempt, which is a mechanism within the Constitution itself and within this election petition's four corners, and a second and another declaration that this person, pursuant to Article 33, sub-article 2, is no longer fit to hold public office. We go further. Is it possible that we can stop it by stopping Mr. Chebukati alone and we submit? No. It doesn't matter whether Mr. Chebukati will find another Mr. Chebukati next time. We have to stop those people who do not take those steps, but who take the benefit of those steps. And those people who take the benefit of the steps which the Constitution itself says is unlawful cannot take public office on the basis of a false 34C, 34D, of a declaration made by a person who knows he's made it falsely, so that we also pray that those who seek to benefit from the wrongdoing of Mr. Chebukati are themselves caught by Article 3, sub-article 2, and you have the powers to make the same orders that they too are making an attempt to establish a government in Kenya otherwise than in compliance with this constitution. And we pray that this court moves our country forward with those two steps of orders in relation to all parties benefiting and all parties carrying out this mass attack upon Kenyan democracy. Thank you.
I pray to the court to allow me to say a few things in conclusion. And I'm honored to come after my senior, Mr. Firoz Norji, senior counsel. I cannot forget to put it on record that in 1993 I filed a similar petition challenging the election of the then president, and my lawyer was Mr. Firoz Norji and Mr. Paul Mwangi, and I'm forever grateful. And so was Mr. Paul Mwite, senior counsel. Many times I was locked up, he was always available to appear for me, and like many other counsels who are here. I want to urge the court that what has been put on record, and particularly the evidence that has come through the submissions of my learned friend, Mr. Morgor, it's so important in terms of making a decision as to what to do with the elections that were held on the 9th of August this year. And Mr. Morgor has put evidence before you which has not been controverted. For example, there's evidence of interference, if not invasion, of the technology infrastructure of IEBC, and the evidence of Mr. George Njoroge, which was covered by Mr. Morgor. I want the court, with respect, to look at what the IEBC has said in return or in response to those very, very serious allegations through Mr. Martin Wachira Nyaga, again was referred to by Mr. Morgor. He does not deny the disclosure of the 6 logs from the 6 servers. In his affidavit, he actually acknowledges the logs which speak to access to the servers without authorization. And he puts the question the other way around. Instead of this matter going into inquiry by the Electoral Commission, he questions the authority of Mr. Njoroge in accessing, in obtaining those logs. And he says the same things about the logs that have been put forward by Mr. Justice Nyang'aya. The authenticity and integrity of those logs have not been rebutted. We are treated to an explanation in the affidavit of Mr. Wachira, in particular about the generation of Form 34C. And those rebuttals do not answer the question as to why there are these unauthorized access to the servers of the IBC and obtaining those particular logs. There is also in the bundle, in the evidence through the affidavit of Mr. Nyangasi, of 2 Form 34Cs, one generated on the day the results of the elections were declared on the 15th of August, And the one that was generated on on the 15th of August 2022 is based on the results obtained at the county level. The next day, again, another Form C was generated. All that is in the bundle of Mr. Nyagasi. Another Form 34C. That one was computed on the basis of the results that were obtained from the polling stations. So we got two Form 34Cs. There is no explanation given as to why there was those two forms. So, Your Lordships, we pray that the orders that we prayed for are justified. But probably in future, there may need to be a thorough inquiry as to what happened. Not just looking at the question of whether Mr. Ruto was validly elected, but looking at the criminality that characterized this entire enterprise. And that is when the Kenyan people will know the truth. But for now, I think the Kenyan people will be happier if this court can make sure that the authority, their sovereign will, is not taken away. I thank you.
Thank you very much for keeping time. We will take one more before we break for lunch. Petition number E001 of 2022, John Njoroge Kamau.
My lady.
I request for indulgence of the court just to introduce three people I'm appearing with, but they were in the other room, they didn't get access to court. And that is Emmanuel Bitter, Christopher Marwa, and Radhika Arora. I would like to put them on record. Thank you.
Thank you. That is noted.
My lady, Madam Chief Justice, my lady, the Deputy Chief Justice, my lords and my lady of the Supreme Court. I don't believe I need to introduce myself again, since I did that right at the beginning, but all I wish to state is I appear for the petitioner, Mr. John, I'm so sorry, Mr. John Njoroge Kamau, who has been called as a surrogate in some of the affidavits, and unfortunately yesterday was called a proxy. My ladies and my lords, Article 1 of the Constitution relates to the sovereignty of the people. Article 3(1) of the Constitution, it is the duty of every Kenyan, and most of us sitting here are Kenyans, to uphold and defend the Constitution. Hence, it is very sad to see that when Wanjiko, or in this case, John Njoroge Kamau, comes to court, he or she is immediately vilified and stigmatized. All he is doing is exercising his constitutional duty and following the law, never wanting to go back to where we went about 15 years ago. And like I said, in social media, everybody gets vilified. We don't need to read social media, as I was told 10 minutes ago. Notwithstanding the same, John Njoroge Kamau, on the 9th of August 2022, in exercise of his constitutional right to vote under Article 38 of the Constitution, went to his polling station to vote for his preferred presidential candidate, and then went home to await the result. It was a long wait for 6 days, but that is not his gripe at all. He is not complaining about the 6 days. As far as he was concerned, he had this legitimate expectation there was going to be a free, fair, credible, accurate, transparent, and verifiable election pursuant to Article 86 of the Constitution. But my poor client, lo and behold, to his shock and horror, at about 4 p.m. on the 15th, a public statement was made by Juliana Cherrera, Irene Massett, Justice Nyangaya, and Francis Wanderi, and I will call them as the 4 commissioners because I won't continue to repeat their names. And in that statement, before the declaration of who he wanted to know was his president, before that declaration, they came out and stated that this election was opaque. Subsequently, at about 6:05, the chairperson of the IEBC declared a result to say who the president-elect of the country was, and this was duly gazetted. To confound it all, on the 16th of August, people started calling, and the 4 commissioners started calling this the Chebukati's results. On the 17th of August, 2022, a statement was issued by the chairperson of the IEBC, and I'm not going to get personal here, I will call him by his title that he's got at the moment, stating the reasons why the 4 commissioners, and the drama continues. My ladies and my lord, this is a voter who is watching all this unfold in public. His simple question is, did my vote matter? Or was it Chebukati's result? Or was it an opaque result? What happened? And that's why that's who I am representing. And I'm very curious for myself. Where did my vote go? Did it go anywhere? Or was it not there? My lords and my ladies and my lords, in order to meet the constitutional threshold of being a credible, transparent, verifiable, accurate process, the electoral process must be conducted in strict compliance of the law. We have filed on behalf of the petitioner very extensive submissions. These were filed on the 26th of August 2022. I am caught in a position where I could sit here and reread everything that's been said or everything that has been reiterated by my learned seniors who are, for once in my life I can say who are much older than me, because normally I'm one of the oldest people in a room, who are much older than me. So I don't wish to repeat everything that they have said, because that we don't have the luxury of time. I will just keep it very, very short, because I am sure your ladyships and your lordships will read the 23-page submissions that we have done. 1. Under Article 138.3 C of the Constitution, it specifically states that after counting the votes at a polling station, IEBC shall, it is not say, may, shall tally and verify the count. That's what our framers said. Article 138.310 now starts distinguishing. It says the chairperson of the IEBC. As yesterday was said by Madam Chief Justice, the framers of the Constitution decided to give you 14 days. It's not easy to complete this election petition. It's got to be done within 14 days. The framers of the Constitution knew exactly what they were doing because of where we had come from, culminating in 2007. Hence, the declaration was to be done by the chairperson, but the verification and tallying, if they wanted to do it by the chairperson, they would have said it. Secondly, If, as is being stated by the chairperson of the IEBC, as he's put in his statement that was issued on the 17th of August, it is me. It is me who has to verify and tally pursuant to regulation. There's a regulation 87.3, which my learned friend Mr. Feroz now took your lordships and your ladyships to. I can do it. If he could do it, why wasn't it said? And if he says he can do it, why do you need a commission of 7 people? Why do we spend so much money, taxpayers' money, on a commission of 7 people? Have 3. This court has ruled that 3 people constitute a commission. Have 3. Why do you need 7? Let's take it further. If it's only him, and according to some of the submissions and arguments that are going to be placed before you, the issue of Schedule 5 regarding quorum, and that he doesn't need quorum, it's only in the normal business. My ladies and my lords, what exactly does the IEBC do? Voter registration, but what is its main function related to? Elections. It is all about elections. That's what they do. I don't believe there's been much boundary delineation, but I will stand to be corrected on that by my learned friends on this side. They may know a little more than that. And so, if it is only the chairperson whose argument is, there is 34A, so there is an announcing declaration there, then there is the polling center, and then it comes to him at the tallying center, and he does it. I still go back to 30 billion shillings on an election, and this is what we've got. It's a very sad state of affairs we are in. One man, let's have a commission of 3, going by what he says. Taking it now to the regulations that he relied upon on the 17th, with your lordship's permission, I would state those regulations, unfortunately, when your ladyships and your lordships decided, as my young associates say it in my office, I don't know how they do it, but they say it, Raila and another versus the IEBC of 2017, they claim that according to terminology they use, it's called Raila 2, and then the subsidiary one, the second one that came, when it came for clarification, they call it Raila 2.5. So I don't know why they do that, but that's what the young lawyers do. So I'm going to use their terminology. When Maina Kiai was decided, and this particular Maina Kiai was decided, I believe it was in, I'd written the date down, but Maina Kiai was decided in June 2017. Subsequently, the chairperson of the IEBC came to your lordships and your ladyships asking for a clarification as to exactly how Maina Kiai was interfering with your decisions in Raila 2. It was so clear on what this court said. And the saddest part is, regulation 87 that he is relying upon was not brought to your attention, and from 2017 to 2022, all IEBC does is hold elections but doesn't look at its regulations. And are these regulations, are these going to be the mundane matters that the commission has to decide? Because we've been told, besides verifying and telling, the commission does everything, and those are in their submissions. My lords and my ladies, if you look at my written submissions, and I'm going to take you through them very quickly as to, if you look at, and the page numbers are verified, the case numbers, we've put in a bundle of documents. What that statement of the 17th of August said, if you could look at page 8 of my written submissions, at paragraph 19 from about line 18, and this is a quote from the Maina Kiai case. It is, in our view, fallacious and flies in the face of clear principles and values of the Constitution to claim that the chairperson of the appellant can alone, at the tallying center or wherever, purport to confirm, vary, or verify the results alone. This honorable court further said the same thing in the RILA 2.5, which is set out at page 11 of the submissions at the bottom. And you go to page 12, this is at paragraph 20, and it will be paragraph 292 of the RILA 2.5. The failure by the first respondent, IEBC, to verify the results in consultation with the second respondent, IEBC chairperson, before the latter declared them, therefore went against the expectations of Article 138.3c. And there are several quotations I have put in there that show that this court has already made the decision. My biggest fault with the IEBC, and it's not particular the chairperson in himself, for 5 years you did nothing. The Supreme Court told you in October 2017, you can't do this. You do nothing. You amend in April 2017, you leave it at that. There's been hardly any amendments. It doesn't matter who's the Kenyan voter. IEBC, chairperson, we own this. It's an independent commission, but they have to work within the ambit of the Constitution. My ladies and my lord, I'm just going back now. Like I said, I have 15 minutes, and I think I'm going to be at a space where I'm going to be a very patriotic Kenyan, and I'm going to donate the time back to the court, because I don't think I'm going to take the full time to finish my submission, because it's fully set out where we are going to. There are three things that we've brought up. One is the issue of the Regulation 87, which has to be made unconstitutional. And we have relied upon the court, the judgment of this court in the case of Rai, where you declared Section 14, where Parliament went way beyond the ambit of what this court was supposed to do. We are relying upon that to declare that, because it appears IEBC is never going to come to you, so we might as well do it once every 5 years to see where they've got it wrong. We're requesting you to declare it unconstitutional. We are going further and stating to your lordships, to your ladyships and your lordships, the issue of the elections, of the cancelled elections. Whilst the elections were cancelled in counties or gubernatorial, and an issue has been taken up that if this court has jurisdiction, because interpretation of the Constitution is in the High Court. My ladies and my lords, Article 101 actually gives a date cast in stone when our elections are going to take place. General Assembly, Parliament, Presidential, the whole lot. So it is on the second Tuesday of every 5th year. Article 101 read with Article 136(2)(a, read with Article 177(1)(a) of the Constitution, and 181, clear, cast in stone. We all know why that happened, because initially dates could be set by whoever they wanted to, and you could have a date on the 29th of December for an election where voters were available or not available. That was the history of that, in a very narrow way. We now have a situation where elections were cancelled. Today we have a chairperson and an IEBC who are so disconnected. What happens if in 5 years from now somebody decides to cancel a presidential election on the basis of a national emergency? This is something that really struck us when we were looking at this. It was something that had never crossed our mind. It's a hypothetical, yes, but maybe some direction needs to be given on that. Secondly, the suppression of voter turnout and voters being disenfranchised. We've been told this entire election is mathematical. Take a calculator and you'll get a result. That's what I've been told. How, if it's as simple as taking a calculator, the national tally that was stated by the chairperson was 65.4% or thereabouts. In Mombasa, where there was no gubernatorial election, and that you can work out from simple mathematics as to the number of people who showed up vis-a-vis the number of people, the voter turnout was 44%. In Kakamega, with a national tally of 65.4%, the total number of voter turnout was 57%. Simple mathematics, even saying that the figures we have are correct. And that is where we've come from, because there was a submission that we've not shown anything. Those two counties were way below the national tally. Whose strongholds they were is not my problem. All we are saying is that there was suppression and therefore voters were disenfranchised. You're cancelling an election at 8 o'clock at night on the 8th for voters the following day. You can imagine the confusion. And what was the reason for the confusion? A mix-up in ballots. This is all in our petition. I am just speaking to your lordships because if you read the petition, all the annexures are there. Oh, sorry, oops, we made a mistake in the ballot papers. There was a mix-up. Yet, there was supposed to be gazettement. A replying affidavit by the CEO, and it was supposed to be done by the 1st of July, a replying affidavit put in this petition by the CEO. Oh, we gave it to the national printers, the government printers, but they didn't print it, and so it should be deemed as done. There are news articles saying 128 ballots came to this country with ballot papers on the 7th of July, 6 days after this gazettement, or 7 days. And it is quite clear that there was an issue with the gazettement. It was backdated. But 128 ballots were already there. And the chairman admitted it, that there was a problem with the machine at the government printers for the printing. Even if you assume that it was printed on time, it was sent on the 1st of July. The earliest it could have been done was on the 2nd of July, because they haven't given us a time. We are voters, we are just watching this. We are watching this drama unfold. That being the case, and on the 7th, 128 ballots came. That's a lot of ballots and a lot of ballot papers. Nobody checked, like I keep on saying, 30 billion shillings later, we can't get an election right because there's a mix-up in the ballot. And therefore, my ladies and my lords, what is happening here is not a way to have an election at any level. We don't know what is going on as voters. People who are listening to this are getting even more confused as to what is happening out there. Was this accurate? Was this verifiable? It's our humble submission. The commissioners who came out, the disconnect between the commissioners shows that there is a problem. Mr. Chebukati says it is verifiable and accurate. The voter, what does Mr. John Njoroge know? The commissioners are saying it was opaque. Where does the voter go? Has everybody forgotten the voter in all of this? The political parties are saying, I won, I won. We want to know what happened to our vote. And where we are today, we actually cannot say that where this vote went and what happened. And in view of that, it's my humble submission that one, the petition be allowed as prayed. And there is a prayer we've requested for, that there should be a nullification of this election, because the sovereign will of the people has not been, well, like I said, what we see. Whilst this court says an election is a process, for me, and even as a lawyer, and for Wanjiko and for John Njoroge, an election is an event. You're going to the ballot, you're going to cast your vote, and you're hoping that your vote counts. We shouldn't be in a position where we hope that our votes count. We should be in a position where we know our votes count. And whilst there is a prayer which your lordships and ladyships might tell me off about, we have requested that the chairperson be prohibited from conducting any further elections in view of his behavior and or holding any public office in Kenya in breach of Chapter 6 of the Constitution of Kenya. The reason why we've said that is, unfortunately, whilst we created independent offices, we forgot about Chapter 6. And I think this court needs to show the way, even if it's to the lower courts or subordinate courts, show them the way that it's Chapter 6 that is going to be a question of integrity. In view of that, my ladies and my lord, I have nothing to add except if anybody has any questions, and please can there not be hard questions.
Thank you very much, Council. You have donated to us 7 minutes. Thank you very much.
Thank you.
For your journal. I think we will adjourn. See. Yes.
Is there something about the all this stuff?
Yeah. 2 o'clock. 2 p.m. Yes. We will adjourn until 2 p.m., but before we do so, I recognize that we have observers who have joined us. Yesterday, during the pre-trial, we formally recognized the observers, but I think they were not present. So on behalf of the Supreme Court, my sister and brother judges and the entire court, we wish to welcome all the observers, especially the delegation from the Commonwealth that is led by our retired Chief Justice from Tanzania, the Honorable Justice Adhman Mohamed Chande, for taking time to come and observe these proceedings. We thank you for taking your time, which is a mark of friendship and also encouragement, and also an indication that we are all pursuing similar objectives of ensuring there is promotion and protection of the rule of law and constitutionalism, and also creation of strong, independent institutions that guard and sustain our democracy. So you're most welcome to the proceedings, and our gratitude for your finding time with eminent judges, jurists, and other distinguished delegates who have committed their time to come and be part of these proceedings. On behalf of the court, we are so grateful. And having said that, I think we will arise and resume at 2 p.m. Thank you.
expert here in studio. But before then, that the votes are being retallied. It's the Nandi Hills in Nandi County. We have Sinendeti Primary School in Nandi County.
One, not two, plus one. That is how you do your math.
Give an example of 10.
That's okay. This first ballot was okay. This was the test. From there we will know what to do.
So, what are we agreeing, Honorable Munwa? Give us direction now.
You know, you can't change facts. 500 minus 272 is whatever you get. Had one. Yes, correct. That's okay. Not two. If you add the two, you get it wrong.
You're counting 1 to 10, and then you get the highest is 10.
Minus 1.
Minus 4, you get 9. So you add back 1.
Yeah, exactly.
So give us direction.
Yes, those are sights and sounds of the tallying process of the 15 polling stations. The court ordered retallied, scrutinized and recounted in 15 polling stations. And earlier on I had mentioned five actually, the fifth one being Kuptum Primary School in Kericho County, the sixth being Jomvu in Mombasa County, Mikindani, Mombasa,
This is polling station. Majengo polling station 2. Where is the PST? Read the code. Read the code. Put it inside. So please read the, what's there?
So this is Vita Majengo 2. Serial number for the ballot box 37 42 30. 37 42 30. The seals, the aperture 030 53 26. 030 53 26. First seal
We'll deal with issue number 3,
54
4,
09.
and 5 as identified by the court.
Second, 030 54
And that
11.
is
030
whether
54
there was a difference
11.
between 4.
Third, 030 54 10. 030 54 10. Last, 030 54 12. 030
Serial number of
54
the
12.
box. So the same
Those are
as
the
the
seals.
P742, the serial number of the box. The serial number of the box. 3742, the seals as per the PSD. 0305 409, the seals as per the PSD. 0305 409, that's the first one. The second one is 0305410. The third one, 0305411. Then the fourth one, 0305412. Okay, let's open the box. 0305 409.
Okay.
So we have 3 packages. Are they 3? The first one is, list them.
First package from 34A,
That's one.
presidential result. Second package, second package, these are stray.
So there's a package of stray ballots.
This one has no label,
Those are the votes cast.
but this should be the votes cast. These are unused.
Unused ballot papers. Okay, so just open them.
That's all we have.
Open them so that we are faster in this one.
From 34A, book 2 of 2.
So we noted what was there. So our report will be very clear on what we have found in the box, because we don't know what else is supposed to be there. Okay? So those, I'm saying, let's note what we find. Whatever else is not in our report, you will then make submissions on them. Yeah. Counterfoils, let's start with
counterfoils are here.
Yes, the counterfoils are there. Please place them the way we had placed them. So we start with the first package. How many counterfoils? Now, Dominic, you must now be, because you know the drill. We are dealing with the counterfoils. Give us the first serial number of the first.
Okay, the first batch PR 00608805. PR 00608805. That's the first one. The last one in that bunch, PR 00609016. PR 00609016. The second bunch starts with PR 00609017. PR 00609017. The last one, PR 00609026. PR 00609026. So those are.
So do the math as we go to the next package. We'll come back to it if there's a problem. Unused ballot papers. The serial numbers, the first.
Unused, the first, PR 0060, PR 00609027, PR 00609027. The last one, PR 00609337. PR 00609337. That's unused.
Okay, let's now go to the ballot papers themselves, the ones that were cast. Divide them amongst yourselves.
Wait.
We'll wait. We've already opened these ones here.
Straight.
We'll open them.
You haven't opened from 34
Yeah.
and then the straight. Open them later. Okay.
Yes.
We can begin. Are we all raised together? This is for William Samoei Ruto again.
You have how many bunches? One?
We have two.
Two. Okay.
So batch one, I am beginning. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 2, 33, 34, 35, 36, 37, 38, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 50.
Is there an issue? Can we know what the issue is?
There's a likelihood that there's a number he skipped. He said 13, then he went to 15.
When he was counting. Can you do like in 50, so that we do 50?
On the hearing of the Supreme Court presidential petition challenging the declaration of William Ruto as president kicked off this morning with submissions from Azimio presidential candidate Raila Odinga, whose lawyers cast doubt on the final vote tallying. Now, the Supreme Court also received ballot boxes for recount as ordered by the judges during the pre-conference on Tuesday, and concurrently ongoing that is in for the House. Now, let us, of course, take a look at that in the next few moments, but also just welcome to our continued coverage of the Supreme petition. Stationed at Milimani Law Courts is our reporter Daniel Kariuki, who has been following closely the proceedings at the Supreme Court. He's going to get us updated on what's happening and also that retallying and rescrutinizing of votes from 15 polling stations as ordered earlier on. Daniel Kariuki, what can you update us on what's going on where you are?
1, 2, 3.
Many law courts, it has actually been changed to the Supreme Court of Kenya, and right now, just like you have put it, it is the retallying of the results from 16 or rather 15 polling stations that had been ordered. The exercise had been ordered by the 7-judge bench yesterday, and as we speak, it's only one polling station that they have managed to do the retallying, and right now they are in the second polling station. And from what they have actually, what we are gathering is that it has taken 1 hour and about 7 minutes for them to do the retallying of that particular polling stations, with about 14 more to go. So the big question is, with less than 24 hours remaining before they have filed the report on the scrutiny of the 15 polling stations, are they going to manage to beat the deadline? I remember the court ordered 48 hours to the retallying of the 15 polling stations. We are going to be following keenly to see how it's going to be going on, and it is actually continuing on the other side of this court. But right now, as we speak, the proceedings have just taken a break, and they are going to be back to proceed with the petitioners arguing their case in the morning from about 9 or rather 20 minutes past 9 or so. The petitioners, the counsel representing the petitioners, the main petitioners, that Raila Odinga and Martha Karua took to the proceedings, and they had been allocated 3 hours. James Orengo was the first one to argue the case and tackled one of the 9 issues that had been consolidated, or rather they had been compiled as issues that were for petitions, and tackled the issue to do with the verification and looking at the constitution. And according to James Orengo, he said that what happened on 9th and 15th, that's the 9th was the election day, and the 15th is when the results, or rather the president-elect, was announced by the IEBC chair Wafula Chebukati, saying that those events, they really violated the constitution, and tried to tackle, or rather mention some of the instances that he felt the instances that caused the commission to go, or rather the IEBC chair Wafula Chebukati, arguing that he went against the law and trying to put it out on how those 2 days events violated the constitution. And also he said that the IEBC went ahead to repeat the same mistakes that had happened in the 2017 election. Remember the 2017 election, there were some orders that were given by the Supreme Court, and James Orengo, as the lead counsel of the first and second petitioner, that's Martha Karua, or rather Raila Odinga and Martha Karua, arguing that they did not conduct the election as it had been, or rather according to the Constitution Article 81, and went ahead to put what is spelled out in the Article 1, or rather Article 81 of the Constitution, on how the election should be carried out, and insisted that the results that were announced were not accurate and they were not verifiable as the Constitution, or rather as the Supreme Court in 2017 petition had directed, and said that they could not manage to verify the results. And also there was the issue to do with whether the technology met the standards of security. That issue was tackled by Philip Murgor as one of the lawyers that are representing the first and the second petitioner in their 3 hours allocation. And Murgor tried to put out on why the system, they believe, did not have the enough security features that would have warrant an accurate, verifiable, free and fair election, trying to put out that the system was interfered with for several times by different people, known people and known people, saying that the system was accessed by different people at different intervals, and used some of the, or rather used some of the affidavits that have been filed in the court to show that the system was interfered with, and there are some individuals who actually logged in, or rather managed to interfere with the system. And the issue to do with the Venezuelans actually came out in a big way. Remember, there was the back and forth between the Directorate of Criminal Investigations and the security agencies, and Philip Murgor says that even after it was said that the Venezuelans had actually left the country, it remains to be, it seems like they were still actually left the country, but they were still in, they could access the system. That was their argument, according to whether the technology met the standards that had been actually set. And also there was another issue to do with the figures. Remember, there was the issue that there was discrepancies between the presidential votes and the other positions' results or votes. And one of the issues that came in is the issue to do with Kirinyaga County, whereby the council, that's Julie, talked about Kirinyaga County having some discrepancies, and one of the issues that she tackled, Julie Soet, said that the Kirinyaga County, there were 23,550 difference compared to the presidential vote and the gubernatorial race, and allegedly said that these explained could not be explained on how there was these discrepancies, and said This was just one of the counties, and maybe that's the reason they were calling for the retallying of several counties, about 7 of them, with the court yesterday saying they do a retally of 4 counties for 15 polling stations spread across 4 counties. That's Nandi, Kericho, Mombasa, and Nyandarua counties. And also said that there were some votes that were being deducted from Raila Odinga as the petitioner and added to William Ruto, who is the second respondent in this case, and saying that the final tally of the count was still the same, but the results were different for Raila Odinga and William Ruto, and used samples of these saying that about 2,793 votes had been added to the second respondent and deducted from the first petitioner. Meaning these are just sample of what they looked into the affidavits that have been filed in the court, trying to show that there were such kind of issue that was going on in matters to do with the votes that had the Form 34A, what had been indicated, and the actual vote that was tallied. Those are just some of the issues that were raised, and also the council said that there was plans and there was rigging in favor of the second respondent, and so calling on the court to nullify the election, and of course saying that the second respondent, William Ruto, did not manage to get the 50+1 vote. Actually, what was making the difference is about 69,000. That is what was making the all difference, and that's what actually put William Ruto ahead in matters to do with the 50+1, attaining the 50+1 vote as it has been put in the constitution. And they say the 69, if they could do the retallying, these votes that had been deducted from the first petitioner and added to the second respondent could have made the difference, and maybe the president-elect who was announced by IEBC Chair Wafula Chebukati, William Ruto, could not have managed to get the 50+1 vote. These are just some of the issues that were raised across the case that was going on, and by the lead counsel in the first and second petitioner and those that are representing them. When we come back in the afternoon, we are going to be having the other petitioners also argue their case. Remember, there are 6 other petitioners from who have been consolidated into one case, and all of them have been given, each petition has been allocated about 30 minutes, meaning if there are 6, we are talking of 3 more hours as we listen to the petitioners argue their case. Of course, we are going to be following keenly to know the other petitioners, what they are going to be raising, and if it is going to be as similar as those issues that have been raised by the first petitioner and the second petitioner. Now, that is just part of what we have. For now, I want to hand it back to studio.
Thank you very much, Daniel Kariuki, for that breakdown of what has happened so far, it being day 1 of those submissions being given by the petitioners. Now, Raila Odinga and Martha Karua's lead counsel, James Orango, told the 7 bench that the Electoral Commission's final tally of the votes, as declared by IEBC Chairman Wafula Chebukati, does not add up. He painted the IEBC as a dysfunctional body, equating the descent of 4 commissioners to the coming down of the Tower of Babel. Let's just listen in.
The Electoral Commission, in his announcement of the final results as borne out in Form 34C, and his announcement of the turnout of voters, which he recorded as at 65.4%, is at variance. And therefore, his calculation of the results based on the percentages cannot be correct. In this exercise, I invite you in this exercise, I invite the court to look at the affidavit of one Edgar Ouko Otumba. That affidavit he swore two affidavits, a supplementary affidavit, and the first affidavit, which he filed on the 22nd of August. And my lords, in that affidavit, he makes the case, and Mr. Otumba has got a doctorate degree in applied statistics from Maseno University, and indeed he did assist this court in the previous petition in 2017. And he talks to the difficulties, that confronts us in terms of the various announcements that the chairman of the Electoral Commission made. And he states that on the 9th of August 2022, the respondent issued a communique, that is on paragraph 10 of his affidavit, on the day of the election, that the total voter turnout at 4 p.m. nationwide was at 56.17%. And that statement update is annexed to the affidavit sworn by the second petitioner, Madam Martha Karua. Then, at the close of the voting, the first respondent again issued a statement that the total number of voter turnout, based on the KIMS kit, was 65.4%, which culminates in a total of 14,466,779 votes. And that communique is borne out in the affidavit again of the second petitioner. In an affidavit that is sworn on behalf of the petitioners, first and second petitioners, Mr. Nyangasi Oduo, in his affidavit, he talks to the Form 34C, and I'd referred to this earlier, where the total number of vote cast is 14,213,000. Now, the same Mr. Edgar Otumba saw a supplementary affidavit on the, I think this affidavit was sworn on, just a minute, on the 20th of August 2002. And I invite you, my ladies and your lordships, to look at this affidavit, because it analyzes several scenarios, including scenarios where the rejected votes are not computed, and scenarios where the declaration made by the chairman of the Electoral Commission as to the manual votes which were cast, which were recorded 86,889, and where those votes recorded as manual votes are computed together with the votes that were transmitted electronically. And then scenarios that would include the constituencies where the votes were declared later, including Ella's constituency. Now,
what we have found is what is there. Yeah. Yeah. What we have found is what we have indicated. What is not indicated was not there. Let's indicate the seals. Seal it. This is the third box we have. We are not even at the tip.
Ndio wafanye sealing.
Now the pictures that are on your screen right now are live from Forodha House, whereby the 45 ballot boxes were received this morning, and of course they were being protected by security officials. And this is just as per an order that was given earlier on to have the 15 polling stations vote cast that are now being scrutinized right there as per to those orders. And this is an exercise that started earlier on, approximately 2 hours ago, and it is going to go on all through the day. The 7-judge bench led by Chief Justice Martha Koome ordered that IBC officials to present said ballot boxes from the polling stations for a recount and scrutiny. Now, of course, a room was cleared right there, as you can see on your screen, in a bid to admit said agents that will be presenting or rather going through that particular exercise, just to adhere to that order that was given earlier on and to clarify any of the issues and suspicions that surround the vote count from those particular polling stations, 15 of them in total. So those pictures that you're seeing right now on your screen are of officials that are adhering to that order that was given by the Supreme Court bench, that is meant to just ensure that they are clarifying any of the possible discrepancies or suspicions on the total vote count that was coming from 15 polling stations in total. So we shall be giving you those pictures, and of course you can see right there it's happening in full glare of the media, and just to ensure a bit of transparency as they ensure that they adhere to that order. And of course, do remember this is happening under the strict eyes of security officials that accompanied those agents with those ballot boxes to the Supreme Court. This is an exercise that shall be happening all through the day, and we shall be keeping you updated on this as it unfolds. But concurrently, do remember, have our eyes trained on the Supreme Court, whereby they're having the lawyers representing the first respondents and the other respondents that should come back in the afternoon are addressing their concerns to the Supreme Court bench. And of course, this is in line with some of the areas of concern, and these are 9 points that we have been keeping an eye on and listening into the councillors that have been before the Supreme Court judge. Earlier on, we heard from James Orengo, who made an argument for the nullification of the ongoing of the just concluded presidential election results, in particular at the presidential level. But let's keep up with the ongoings at Forodha House and just listen into what they are saying as they retally said ballot boxes and votes within.
Aperture, I'm repeating, 0, 3, 0, 5, 3, 2, 6. That's the aperture. The first seal, 0, 6, 7, 9, 6, 3, 3. 0, 6, 7, 9, 6, 3, 3. Second seal, 067 9632. 067 9632. Third, 067 9634. 067 9634. Fourth, 067 9635. 0679635. This is Vita 1.
Yes.
Vita Primary School.
Yeah. As per the PSD. Okay. That is the one we have just sealed. Okay. Where is the PSD for Majengo? Majengo 2. Okay. Let me finish this and then I'll give the registrar an opportunity to make an announcement. That was page 18, 17, 18. So the aperture was 0305326. 0305326. Is that clear? Okay, so let me give Honorable Washira time.
There is an issue with order number 7. Order number 7 that talks that IBC should provide certified copies of Form 34A and 34A Book 2. And the applicants were supposed to avail a list of the contested polling stations for compliance. I have received a list of 517 from one applicant, 238 from another applicant, and the other applicant has asked for countrywide 46 to 29. So I have consulted with the judges, and the judges are going to make a clarification at 2 o'clock before the session starts. So anybody interested in getting the direction in respect of that particular order could probably listen to the proceedings. Thank you.
Thank you, our registrar. Let's now go to the third ballot box. I said we are not making good progress, but let's see.
Okay.
So this is in respect to Vita?
1.
1. There are 7. So
Vita
1
primary.
of 7.
Yeah, 1 of 7. Serial number of the ballot box 271-187. 271-187. Aperture seal. Oh, what did I say? Aperture seal 0, 1, 9, 1, 4, 6, 5.
You know, we are now on the third box. The other one was the Majengo one, which you were sealing, and you were clarifying it in respect of those who had not heard about the serial number for the aperture. So now we are on a fresh box.
Vita Primary School, 1 of 7. So aperture. So aperture 0, 1, 9, 1, 4, 6, 5. First seal. First seal 0, 1, 9, 1, 4, 0, 1. 0, 1, 9, 1, 4, 0. 0, 1, 9, 1, 4, 0, 1. Second seal 0, 1, 9, 1, 4, 0, 4. 0, 1, 9, 1, 4, 0, 4. Third seal 0, 1, 9, 1, 4, 0, 2. 0, 1, 9, 1, 4, 0, 2. Next seal 0, 1, 9, 1, 4, 0, 3. 0, 1, 9, 1, 4, 0, 3.
So even as he breaks the seals, as per the PSD, the ballot box that we are looking at was indicated as 27. That's the serial number 271187. 271187. The seals that were used to close the box at the end of county 1, 019, 1401, 019 1401, then 2 019 1402, 3 0191 403, then 019 1404. So 1, 2, 3, 4. The rest of the numbers are the same. That's okay? Okay, let's now pour the contents. Let's see whether we can be faster in this one. So list of the packages that we have. You can see they are not in a package. So put them together. Those should be the votes that were cast. Not packaged, but they are there. Yeah.
Vote cast?
Yes. Yeah, just record that they are not inside a sealed package, isn't it? An envelope.
These are votes cast.
There are how many rolls? That's one.
This 1, 2,
3, 4.
3, 4. So this is a bunch. We count each.
No. We'll open. Just put them aside. Let's deal with the next packages.
So this is a used KIMS supervisor validation forms. Oh, okay.
The third one?
Third one is unused ballot paper, presidential.
Fourth
is used counterfoils, presidential. This unused form 32.
Unused form 32.
Unused KIMS supervisor validation form. Next package. Unused tally sheets. Manual register. Governor booklet. Presidential result booklet. Unused presidential seals. Used presidential seals. Stray ballot papers. Form 34 carbon copies.
Okay, so we open.
Rejected ballot papers.
Wait, how many packages? 8? 14. Okay, so we go one package per. So how all this? Let's start with the ones which are not packaged. Let's not open them. Yeah, counterfoils. Yes. Okay. Then once we are dealt with the counterfoils, you give to the next team to close, to seal, and so that we are faster.
So when they come, then we
take care of it. Okay. So those are the counterfoils.
The counterfoils.
Let's get the numbers.
The first number, PR 0 0 6 3 4 9 2 4. PR 0063 4924. The last PR 0063 5183. PR 0063 5183. Just one bunch.
Okay, so we want to split this work so that you don't get involved with the resealing. I want this to go to the next table for purposes of resealing. We've gotten the numbers. If we have an issue, we'll recall it. So go to the next package.
Unused. Unused.
Unused ballot papers.
Ballot papers. First one, PR 0 0 0 6 3 5 1 8 4. PR 0 0 6 3 5 1 8 4. The last one, PR 0 0 6 3 5 5 7 7. PR 0 0 6 3 5 5 7 7. The last one. Repeating the last one, PR 0 0 6 3 5 5 7 7.
Okay, that is. So you move it to the next table for resealing. Let's get the next package. You're opening? What are you opening?
I'm opening the used KIMS supervisor validation forms.
Do we need to open this? Now that we are not... do we need to know the contents of this package? Okay. So, okay, let's be all on the same page. What are you looking at?
This is I'm looking at the KIMS supervisor validation form.
How many copies?
The number of forms. It's 1, 2, 3, 4, 5, 6.
Are they copies of the same or different?
7, 8, 9, 10.
They are copies of the same? Originals. Okay. Yes. So how many copies? 10. Yes, original copies. So let's reseal them. Next, open. Next, yeah, any. Let's just open any. Yeah, just open. 34, let the 34. Yeah.
Stray ballots. Hizo zingine zinaweza funguliwa. So these are the stray ballots. You have 2. For one Majengo ward and 2 Majengo ward.
So in respect to MCA.
So this is MCA 2 stray.
Seal them. Give it to the next table for resealing. Yes.
These are used presidential seals. Used presidential seals, therefore.
Just put them in.
Rejected ballot. Rejected ballots, there are 2. Must have been a teacher.
And the other? It's obvious these were rejected.
Yeah.
Okay. So let's have them back in the package, sealed.
Governor booklet.
So this is a governor booklet in a presidential box. Just note it and let me know whether you want to see the contents of it.
We have 2 booklets.
Yeah. Put it back. For sealing, let's go to the next.
Unused KIMS supervisor validation forms.
Unused. Yes, just open. Let's see. Because we opened the other one. The used ones. So you can see they are empty. And no entries.
Do you count?
Just count.
Okay. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12.
So unused KIMS kit verification forms. 12. Seal them. What is that you're looking at?
So this is unused from 32. It's quite a number.
There are quite a number, just there are many. Do you want to know the number of the unused Form 32 or you want to know the number? Okay, count. 1.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 37, 38, 39, 40, 41, 42, 43, 44, 45, 46.
46 unused Form 32 is? Next.
Unused tally sheets. Unused tally sheets.
Just let's have unused tally sheets. I don't think we need to keep counting them. Yeah, we'll. Their number. If they are unused, they are unused. I don't know. The number of unused.
Okay, we are counting.
One. Count them. You see, even the more we argue, just count them. If we are, then we will make a decision after this box. Count them. 1.
Okay. 1.
Yeah, we will do this one, but going forward, we may have to make a decision.
Yeah.
Yes. Yes. Yeah. We'll make a decision. Don't worry. We'll count this, but I will make a decision.
Okay. So we are counting. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 1, 2, 12.
12. Next, give it to the next table.
Manual register?
Yes, just show them that this is the manual register that was used.
You have the manual register. What confirm whether it was used? Yeah, it was used.
No, we can't find. There are so many.
What you do, just pass it round as we go through this. You can do the counting. I'll ask somebody else from this table to do the counting. But you know, we are doing a scrutiny. A scrutiny is you look at every electoral material that is inside the books. So to the extent, we will see how we will manage time. That's why I'm saying we might not do this with this table. You people count, we will confirm how many people, voted using that. So can we use the papers? This is, what are we looking at?
Okay. Presidential result booklet. Presidential result booklet. There's one. For it's empty.
This is a blank.
The serial number PR 0 0 2 0 6 2. PR 0 0 2 0 6 2. It's blank. Yeah.
The next, that is 34, yeah, another one.
This is from 34A carbon copies.
Okay, delete that one. Let's deal with this first, because we might have to, if it is populated, we might have to do comparison. Let's deal with this. Yes, the votes now. So we have 4. You're dealing with which batch?
Ruto.
So Honorable Wera is dealing with William Ruto's. There are 2 batches. 1. Count them.
We are ready? Are we all ready? Okay, we can begin batch 1. 1, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 37, 38, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 50, 51.
You didn't follow the counting.
51, the budgets are supposed to be 50. So if 51 in the batch, it's good to just confirm that that's the actual count. Indeed, that's why we said in that station, Form 34A results are different from what we received on this table.
So you want a recount of this? Just a recount?
Yes.
You see, the more we talk, the more we waste time.
Thank
so
you.
Just do a recount. Haraka haraka.
5,
And
6,
please begin.
7, 8, 9, 10. 1, 2, 3, 4, 5, 6, 7, 8, 9, 20. 1, 2, 3, 4, 5, 6, 7, 8, 9, 30. 1, 2, 3, 4, 5, 6, 7, 8, 9, 40. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 15.
Okay. Confirms. Thank you. Okay, let's go to the next.
Okay, we'll be careful.
So be careful, yes.
1, 2, 3.
This is the second batch.
3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 37, 38, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 50, Am I too fast?
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 1, 2, 3, 4, 5, 6, 7, 8, 9, 20. 1, 2, 3, 4, 5, 6, 7, 8, 9, 30. 1, 2, 3, 4, 5, 6, 7, 8, 9, 40. 1, 2, 3, 4, 5, 6, 7, 8, 9, 50.
100. So let's go to the next. We are done. No, we are done with Ruto, isn't it? So we'll deal with Raila. So there are 3 batches. The first batch. Yeah, let's deal with the batch. So you do it. Okay.
Okay, give me. Okay, these are ballots. The first batch for Raila Odinga. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28. Batch 1, 28. We're now counting batch 2. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 37, 38, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 50. Second batch, 50. We're moving now to the third batch. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 37, 38, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 50.
So the three batches do the calculation. 128. Let's go to the next presidential candidate. So you are dealing with?
It's a batch for William Samoei Ruto. Yeah, batch for William Samoei Ruto.
So there were three batches.
Submissions by the petition by the on behalf of petition number 2 of 2022, that is the Youth Advocacy Africa and Peter Kireka. We would like to clarify some issues arising from the scrutiny that is going on, and I will request my brother, Mr. Justice Naura, to do that on our behalf.
Thank you, CJ. We have received information from the registrar of the court that parties have been unable to agree on how to conduct the exercise in order number 7 of the directions given in the ruling on scrutiny and recount. That order reads as follows: that IBC should provide certified copies of Forms 32A and 34A Book 2 used in the imputed election, subject the applicants providing the IBC specific contested polling stations for compliance thereof. We thought, in our wisdom, that order is specific to contested polling stations, but what we have instead, Otieno Gola writes and said he wants the Forms 32A for all 229 stations. Joachim Bosch and company write and say they want for 238 stations. I believe the petitioners, first petitioners, have asked for 517 stations. Obviously, with the time we have, and you've already spent the whole day haggling on this, 24 hours or 48 hours are gone, it is now impossible to comply with that order, and therefore, the court directs as follows. The applicants shall only, the IBC shall only provide the 32As and 34As Book 2 from 41 stations, polling stations, that are in the affidavit of Celestine Anyango Opio. That is the only way that exercise can be can have meaning. And that those forms will be a sample for which you can submit in accordance with your pleadings. We cannot allow you, we said, to go outside your pleadings, because what's happening now, we are creating a new case out of these forms. So please stick to your pleadings, and once we get those the report on those forms, you submit on them in the context of your pleadings. And so, Caleb Khalifa's petition, Willis Otieno's petition, Willis Otieno, the petition by Raila Odinga, and the petition by Joachim Bosch. Those are the 3 petitions where these issues arise. Please submit only on those issues. I hope I'm clear. And we don't expect debate on these. We expect compliance. I thank you very much, CJ. I thank you, Council. And remember, CJ, and Council, this exercise must be conducted before 2 p.m. tomorrow. What is will be undone by tomorrow will be undone. I thank you.
Thank you, Justice Renaura.
My Lady, the Chief Justice and members of the court, we are also having difficulties with the orders relating to inspection of the servers. We have been given restricted access only to the result transmission system, and only it has not been granted yet, only to one server, and it is established that the IBC has got 8 servers. We have taken the decision to write formally to the registrar in the hope that the court eventually can resolve this matter as quickly as possible, because we are running out of time. But there's no compliance in terms of the orders that the court gave.
We are aware about that issue. We are following up on the question, and as far as we know, the exercise is continuing. Should there be an issue later in the day or tomorrow morning, we shall receive a report. But as far as we know, by the time we got out of here, the exercise had commenced. There was an agreement on how to access the server that was given, and the issue of cloning is being addressed. So let's leave it for now. Let's report again tomorrow morning. I thank you, CJ. I thank you, Mr. Orengo. We are aware about that issue.
May I, with your very kind permission, Madam Chief Justice, I would like to rectify a mistake. We intimated to you yesterday that the 2 commissioners, Professor Guleye and Boya Molu, would have separate representation. That has been achieved, and we have Dr. Willie Mutumbwa, who is in court, and we have for Mr. Professor Guleye and Mr. Peter Wanyama for Commissioner Molu. Thank you.
Thank you. That is noted. We can now proceed to invite counsel for petitioner in petition number E002 of 2022.
Thank you very much, Your Ladyship, the Chief Justice, members of the court. I wish to make submissions this afternoon before you on behalf of the 3rd petitioners in the consolidated petition. The petition filed by the 3rd petitioner, initially as petition number 2 of 2022, raises or has issues that deal with all the issues that had been framed all 9 issues that had been framed for determination by the court. But in respect of issues number 1, 2, 3, 4, 5, and 6, I will rely on the written submissions that we have filed or that have been filed on behalf of the 3rd petitioner. And I will utilize my time on my feet this afternoon to focus on issue number 6, the conjoined issue number 7, number 8, and number 9 of the issues that the court framed or the court has framed for determination. I wish to get straight into issue number 6, and my humble understanding of issue number 6, and I will read it just for clarity: whether the IEBC has carried out the verification, tallying, and declaration of results in accordance with Article 138(3)(c) and 138(10) of the Constitution. Again, it is my humble understanding from the manner in which that issue is phrased that what the court is inquiring into is not whether tallying and verification should be done in accordance with Article 138(3)(c) and 138(10), but indeed whether tallying was carried out by Article 138(3)(c) and 138(10) by the IEBC. Time was taken by my learned senior colleague, Mr. Paul Mwangi, earlier on this morning, to make submissions as to what the IEBC is, the meaning and definition of the IEBC, and what amounts or what body or group of people then amount to the IEBC. And that is a submission of law, and I don't intend to repeat the submissions that were made by my learned senior colleague. But the issue as framed in number 6 invites a detailed factual inquiry. And that factual inquiry is the factual question of, was the tallying and verification during the or after the presidential election that is the subject of these petitions indeed carried out by the IEBC. I wish to start my submissions by referring you to a press statement. And that press statement is by the chairman of the IEBC. I believe he's the second respondent. That press statement is dated the 17th of August 2022, and that press statement is to be found in volume 4 of the third petitioner's documents at pages 493 to 496. That press statement is dated the 17th of August. It is headed, the subject is staff murder, profiling, and misleading reports on the presidential election. It is under the hand of the chairman of the IEBC, and it is divided into 3 parts. I wish to focus my submissions on part 3. And part 3 is headed Declaration of Presidential Results. And I submit that this press statement is important because it is the first account by the second respondent as to how tallying and verification took place. In line 12, he states, for the avoidance of doubt, the law provides that the chairperson of the commission is the returning officer of the presidential election. I will emphasize on that the chairperson of the commission is the returning officer of the presidential election. I will make submissions later on in my submissions, and I will hope to persuade you that there is no such position as the returning officer of the presidential election. It is a creation of the chairperson of the IEBC, and it is created for the purposes of executing a very calculated scheme. Be that as it may, I wish you to then go on to the second paragraph from the end at line 34, where he says, as per Article 86C of the Constitution of Kenya, the results from the polling stations are openly and accurately collated and promptly announced by the returning officer. The next sentence is important. It is also important to note that Regulation 87 of the Election General Regulations provides, and he then goes on to state, that he, as the chairperson, is the one who is then empowered to tally or to verify and tally the results. Again, later on on page 495, he goes on to state, this constitutional mandate, and he's talking about the mandate to tally and verify, this constitutional mandate falls squarely on the chairman of the commission, who is the national returning officer. Again, he repeats that, as gazetted in Gazette Notice number 4956 of the 28th of April 2022. The role of the national returning officer for the presidential election is not a shared responsibility and not subject to plenary discussion of the commission. Very important, because at the end of the day, this is how the second respondent then tallied, verified, and declared the results, but we will get to that later on. He states in the paragraph beginning as the gazetted national returning officer that in the spirit of teamwork, the chairperson involved the commissioners. That is all he did. In the spirit of teamwork, he felt that there was no duty to involve them. All he did was involve the commissioners. And again, later on during my submissions, I will get to that. My learned senior colleagues who submitted before me dwelt in detail on the content of Regulation 83. The content of Regulation 83.2 and Regulation 87.3.1, Regulation 87.3 in its entirety, and the manner in which those two regulations enable the chairperson singularly to tally or to verify and tally results in the presidential election. I do not wish to take any time to go through those two regulations, merely to state that it is my humble and respectful position that those two regulations are inconsistent with the provisions of Article 138(3)(c) of the Constitution, because they enable the result in the presidential election to be verified and tallied in a manner other than envisaged by the Constitution. There is a substantive prayer in the petition to declare those two regulations unconstitutional. And I state for that reason that relief should be granted. Later on in my submissions, I will then make submissions as to the consequence of those regulations being unconstitutional and having then hopefully being declared unconstitutional by this court. The fact that the tallying and verification of the result in the presidential election was done solely by the chairman is laid bare in the provisions of Gazette Notice number 9540 of 8th of August 2022. This again was referred to by my learned senior colleague Mr. Firoz Noroji whilst he's on his feet, and this Gazette Notice is to be found at page 36 of the affidavit sworn by the second respondent and drawn by the firm of my good and learned friend Mr. Eric Gumbo and Associates at page 36 of that affidavit. Mr. Noroji took the court through that affidavit extensively, through that Gazette Notice extensively. I only want to emphasize that before the election, the chairman of the commission is clear that it is he who will tally, who will verify and tally the results. And for some reason, the chairman has the chairman of the IEBC had the propensity to publish Gazette Notices even where he didn't need to, because there was no need, there is no statutory basis or regulatory basis or even constitutional basis for gazetting the result pathway. But he went ahead and did it. And it is clear, and I submit it is admitted by the chairman of the IEBC exclusively, to the exclusion of the rest of the commissioners of the IEBC, tallied and verified the result for the presidential election. So as to determine conclusively that the tallying and verification was done exclusively by the chairman, it is again important to ask the question, where were the other commissioners? Where was the rest of the IEBC as the chairman was tallying and verifying the results? Again, I wish to refer you to the same affidavit that I have, the affidavit sworn by the chairman and drawn by the firm of G&A Advocates on the 26th of August this year. And it starts from the second paragraph. He states in the second paragraph that in my capacity as the chairperson of the commission, I was the returning officer of the presidential election. He then goes on later on in the affidavit at paragraph 45 to state that for the proper management of roles at the tallying center of the presidential elections, I had designated in writing specific roles to each of the commissioners and other commission staff. Annexed here to as WWC 9 is a bundle containing the said communication. Again, this bundle and this communication is important, members of the court, because it states clearly what the other commissioners or the roles that the chairman had designated the other commissioners to do. At page, their roles are set out there. Terms of reference of your appointment provide liaison between the Presidential Returning Officer, who is himself, and the National Communication Center, preparing periodic briefs for the Presidential Returning Officer to address the media, briefing the Presidential Returning Officer on electoral activities across the country. Nothing to do with tallying and verification. The two subjects of that letter are commissioners of the IBC. The next letter is on page 42, also dated the 22nd of July. This one is addressed to Commissioner Francis Wanderi and Commissioner Irene Masit. Again, under the hand of the chairman, and it is appointment to the Logistics, Welfare and Security Team at the Presidential Tally Center, Bomas of Kenya. Again, he appoints them in the second paragraph. Consequently, you are hereby appointed to oversight, provide policy direction and strategy formulation for the welfare and security team of the Presidential Election Tallying Center. He then states their names and he states their terms of reference as security of the Tally Center and installations, the Tallying Center's logistics, planning and organization, security of members of the commission, staff, VIPs and other visitors, transport for commission staff, any other duties assigned. Important, those are two commissioners. None of them has been assigned to tally and verify. The third letter is on page 43, and this one is addressed to Commissioner Justus Nyang'aya. Again, Justus Nyang'aya is appointed to be in charge of dignitaries and protocol. And in the second paragraph, he is told that as team leader for dignitaries and protocol, he will be responsible for providing support services to the Commission, managing protocol of dignitaries and VIPs, managing access to the Presidential Tally Center for accreditation, for accredited media, observers and agents, and any other responsibility. Now, those are out of 6 commissioners. Those are 5 commissioners. None of them is assigned to tallying and verification. There is a last letter, also dated the 22nd of July on page 44. This one is addressed to Commissioner Professor Abdi Guliye and Mr. Marjan Hussein Marjan. I wish to point out to this court and ask the court to note that Marjan Hussein Marjan is not a commissioner, but he is merely the CEO of the IBC. Now, these two are appointed to the results management team at the Presidential Tally Center. Their duties are undertaking quality assurance of result forms received from the Presidential Returning Office desk, tallying and processing of election results. I urge that that is the language of Article 183.3, and assisting the Presidential Returning Officer in managing a record of the election results. Tallying and verification, I submit, on the admission of the chairman of the IEBC was done by Professor Abdi Guliye and Marjan Hussein Marjan, and not by the IEBC. The tallying process continues unconstitutionally as it was being conducted, and I want to pose the question and attempt an answer to the question: how does that process then end? That process ends as set out in paragraphs, again, the same affidavit of the chairman, at paragraph 76 onwards. But the story that he tells, or the deposition that he makes, starts in paragraph 66. And I will read it because it is important. He deposed: shortly after 2 p.m., the commissioners and I had a meeting to be briefed on the final results by the commission secretary, stroke CEO, an alternate leader of the Tally Center. The meeting was only for a briefing. He then goes on to say, the briefing was to be done before my declaration in accordance with Article 138(10) of the Constitution. So according to the chairman, all that was going to take place between him and the commissioners was a briefing, and he then goes on and declares the results. What did he do? After he narrates the story of the visit between paragraph 67 and 75, he then goes on under the substantive heading, Commission Briefing of Final Results. After the NSAC team had left, the Commission Secretary and Chief Executive Officer, who was also the alternate leader of the team of the Tallying Center, Mr. Marjan Hussein Manjan, walked into the boardroom. The purpose of the meeting was to receive the final tally of results of the presidential election before I could proceed to declare. From the chairman's own evidence, he assembles a team that comprises Professor Gulie and Mr. Marjan. They tally and verify the result, and Mr. Marjan is merely coming to brief the commission. What happens after that? There is between paragraph 77, where he states that copies of the results were handed to the commissioners, and that is all that was done. The result had been tallied and verified elsewhere. The copies are merely handed. There is a conversation. There is no agreement. And of importance, at paragraph 81, the chairman depones as follows. I walked out of the meeting room accompanied by Commissioner Professor Gulie, Commissioner Molu, and the Chief Executive Officer. And he then went to the auditorium and declared the results. In the chairman's own words, and I submit that his narrative of what took place is important. That is how the tallying and verification of the result in the presidential election took place. To answer or to attempt an answer to the question that is sought by this court by framing ground number 6 as it is, whether IBC carried out verification, tallying, and declaration of the results in accordance with Article 138(3)(c) and 138(10), I would answer that question in the negative. Tallying was carried out by the chairman alone. At best, the chairman, Professor Gulie, and Mr. Marjan. A quick look at Section 5(1) of the IEBC Act would disclose that those three gentlemen, however eminent, are not the IEBC. What the Constitution enables the chairman to do on his own is to declare the result. I submit that the election is a process, it is a progressive process, and the completion of one process enables another. If you do not complete voting, you cannot tally. If you don't complete tallying, you cannot declare. I submit that tallying and verification, having not taken place as provided by the Constitution, then there was no result for the chairman to declare. There is an attempted justification by the chairman for his decision to tally and verify the result on his own. That justification exists in an affidavit sworn by the chairman. This time it is drawn by the firm of Iseme Kamau and Maema Advocates. It is at page 14, at paragraph 62. The chairman attempts to justify his decision to tally and verify alone from this court's decision in Raila 2017. With tremendous respect to the chairman, the issue of his ability to tally and verify on his own was not an issue in Raila 2017. And with the clear provisions of the Constitution, in Article 138(3)(c), there can be no judicial foundation for the chairman's tallying and verification on his own. At the beginning of my submissions, I had submitted that I wish to demonstrate to this court that the chairman executed a very well calculated scheme to grab the election and to run the election on his own. And this is how, in my estimation, he did it. Elections are normally commenced by a notice of elections that is issued under Section 14 of the Elections Act. Regulation 12 of the Elections General Regulations then provide that certain specific notices will be issued for the presidential election. Regulation 12.2 provides as follows: immediately after the publication of a notice under Section 14, and the notice under Section 14 of the Act is published by the Commission, the returning officer of every constituency shall notify the holding of a presidential election in Form 8. Now that's important, because I had also said that earlier on that there is no such role as a presidential returning officer or national returning officer. And I say so because of the provisions of Article 138.2 of the Constitution. Article 138.2 of the Constitution says, if two or more candidates for president are nominated, an election shall be held in each constituency. An election shall be held in each constituency. A returning officer is defined in Section 2 of the Elections Act as a person who conducts an election. The chairman is merely enabled to declare. The conduct of the election, by dint of Article 138.2, is by 290 returning officers. The notice that they were required to publish under Regulation 12.2 was never published. The 290 notices from the 290 returning officers was never published. There is no position like the national returning officer. So the first infraction is that there are no notices. The chairman constitutes himself as the national returning officer, and the notices are not published. The chairman gazetted himself. I believe the gazette notice, I think it is the 22nd or 28th of May. He gazetted himself as the national returning officer. As a matter of good electoral practice, returning officers are gazetted with deputies. The chairman gazetted himself with no deputy. It was his election to run as he saw fit. There is the issue of the deployment or the unilateral transfer of returning officers. My learned colleagues who appear for the commissioners have dealt with that extensively in their affidavits, and I'm sure they will submit on it when they have their time on their feet. Again, the deployment of commissioners at Bomas was not accidental, it was deliberate, it is documented, and the details are spelled out, the duties are spelled out in detail. Again, the postponement of the elections is another issue, and I wish to pose this question at this juncture. We have interpreted constitutional time as being strict, but the chairman of the IEBC has on more than one occasion dealt with constitutional time as if it is elastic. The elections that he postponed on the 8th of August were not the first elections that he postponed. In the second week of March 2000, the then sitting MP for a constituency in Kwale called Msambweni passed away. The Constitution provided that by-election be held within 90 days. That by-election was not held until the 20th of December 2020. Again, that is another election that was postponed, and it just went by. The manner in which the commission conducted itself, or the chairman conducted himself, around the commission dealing with these very petitions is also instructive in the manner in which the chairman had, assumed certain roles and capacities to himself. I wish to refer to the affidavit of Juliana Cherere, filed in this court on the 26th of August. And I wish to refer members of the court to the last filed in court on the 22nd of August. That letter is dated the 24th of August, 2 days after the petition is filed. Annexed JC12 or JC13 is a follow-up to that letter. There is no response, or there is no response by the chairman to the initial memo, and there is a follow-up now asking for a meeting on Friday the 26th at 9 a.m. at the Commission's offices to discuss that purpose. Of tremendous importance is the letter, or is the internal memo exhibited as JC14. This is a response to the request for a meeting. This one is not under the hand of the chairman, but under the hand of the CEO, where he convenes that meeting for today, the 31st, the first day of hearing. Is that a chairman acting in the best interest of the Commission? Is that a chairman acting constitutionally responsibly? The effect of the unconstitutionality in the election was dealt with by this court's decision in Joho 2014. Anything done under that unconstitutional piece of legislation is a nullity. In the brief time that I have left, to answer the ground number 7, it is impossible to tell whether the returned candidate garnered 50% plus 1, because the process by which that finding would have been made did not take place constitutionally. The election having been conducted as it was, there is no result. The votes that were cast by the people of Kenya having not been properly tallied and verified, or verified and tallied, there can be no declaration. I wish to assert the submission made by my learned senior colleagues that an election is a sovereign process that belongs to all Kenyans. And via the Constitution, we have delegated the management of that sovereign process to the IEBC. It was a constitutional infraction of monumental proportions for the chairman to seize the election as he did. And for those reasons, it is my humble request that all the prayers that are sought in petition number 2 of 2022 be granted.
Thank you, Council. Next. Yes.
If may please, my lords and my ladies, I start by saying that election is a process. I'm Otieno Willis, appearing for petitioner number 4. Election is a process that ends upon the determination of the true wish of the voter. And when that process is unconstitutional, it is not enough to throw numbers that are arrived at through an unconstitutional way to assert that that is the true will of the voter. The first issue I wish to address, my lords and my ladies, is issue number 6. And issue number 6, core to it, is Article 138(3)(c) of the Constitution, which vests upon the IEBC the duty to tally and verify results from all polling stations and to declare the result. I want the court to take note of the last part of Article 138(3)(c). The IEBC shall tally and verify the count and declare the result, not the results. Results is the numbers. Result, without an S, is the outcome. And I want the court to notice that 138(3)(c is a responsibility on the commission, not on the chairman. So the first declaration of the results of the verified and the tallied counts is made by IEBC as a commission. Then the chairperson, again, the word of the Constitution used is the chairperson in Article 138(10) shall now proceed to formally declare the results and issue the certificate. My Lord and my ladies, Article 138(3) sets out a 4-tier process. Tier 1 is the polling station. Tier 2 is the constituency. Tier 3 is the National Tallying Center, in brackets, IEBC Commission. And Tier 4 is the chairperson. Tier 2 cannot function without Tier 1. A constituency cannot function if polling fails at the polling station. A returning officer cannot go to a polling station and make a declaration of the results of that polling station. It's not his function. The IEBC as a commission cannot go to a constituency and fill Form 34B for a particular constituency. If they do so, they failed it. Similarly, the chairperson cannot move from Tier 4 and go to Tier 3 and purport to verify and tally the votes, the counts, and make a declaration. Each tier must perform its function. It is now tried that under Article 81, elections must be conducted by an independent body. The presidential elections whose results we are disputing were conducted by an independent individual, not a body. Because if it was a body, I would not have been served with documents from commissioners confirming they did not participate in the verification and tallying of the count. A majority of the commissioners, IEBC in their replying affidavits served upon me, has confirmed they did not tally and verify those results. My lords and my ladies, I wish to state, Chapter 15 of our Constitution establishes constitutional commissions and independent offices. Where the Constitution desired a function to be performed by an individual, it established an independent office. The Office of Auditor General, the Office of Controller of Budget. But where it desired a function to be performed by a commission, it established an independent commission. The Office of Election Management Body is a commission. It is not established as a chief elections officer as an independent office, as Wafula Chebukati seeks to run the commission. My lords, if the people of Kenya desired to have an individual, they would have simply reverted back to 1988 when we had a supervisor of elections. I will not go back into what has been submitted, but only to add on that point that where a commission has been properly constituted and the number is set as an odd number, the Constitution and the law presupposes there may be dissent. And the oddity of the number is to make sure that ultimately a decision will be arrived at. In this particular case, the oddity of the numbers led to a decision of the commission. And a majority of those commissioners have told us in their affidavits that they did not carry out a tally and verification of the results. Tier 3 failed. Confirmed. Let us go to the state of mind of Mr. Wafula Chebukati on the 15th when he was conducting this function. Just to confirm to you that he did it himself. In page 12 of volume 1 of my documents is a statement dated 17th of August by Wafula Chebukati, in which he says that it was his sole responsibility and that the commissioners had no role in that process. That was his state of mind. But the same person, when he comes to court in his replying affidavit, at paragraph 75, 76, 84, 85, he turns around and says, the commission in a collegiate manner arrived at a decision. Why is he lying? If on the 17th he has told us it was his sole responsibility. When he comes to court now, he says the verification was done by everybody. And it's important that I point out in the replying affidavit by William Ruto at paragraph 16 and 17, he also says that it is the sole responsibility of the chairperson to verify and to tally the results. That was their state of mind. But we are submitting it is not the law. The law is everybody must conduct it. These issues which we are raising were canvassed in the Maina Kiai case. Hele Khalifa, the petitioner number 1 in this petition, was a petitioner there. And the court said the IEBC, as opposed to its chairperson, upon receipt of prescribed forms containing tabulated results for the election of president, electronically transmitted to it from the near 40,000 polling stations, is required to tally and verify the results received. That was the law in Maina Kiai. And they go further to say the architecture of our laws is that the power to tally and verify cannot be vested in an individual. Supreme Court Raila Odinga 2017, the court said in paragraph 292, the failure by the first respondent to verify the results in consultation with the second respondent, IEBC and the chairman, failing to act together in concert, meant that it went against Article 138(3)(c). That was binding. To drive this point home, my lords and my ladies, taking into account those two decisions, the number of IEBC commissioners are 7 plus the chairperson. The number of Supreme Court judges are 7 plus the Chief Justice. If, as been...
Counsel,
yes.
Do I understand you to be comparing the Supreme Court, its architecture, and the IEBC?
No. I wanted to give an example.
Be careful. Counsel.
Okay, I'll try to be very careful. I'll try to be very careful and not extreme. I just use the number of 7. That in terms of 7, the Supreme Court sits as a full bench when constituted. And the rules on arriving at a decision is by majority. And there have been even instances when the Chief Justice of this court has been on a minority. And we never saw a Chief Justice walking out there saying, my minority decision is the decision of the Supreme Court of Kenya. In the instance petition, we have the chairman and Gulie and Mr. Bolu walking out saying, our minority decision is the decision of the IEBC. How absurd can it be? And to buttress that point, Mr. Nyamodi has clarified what roles were given to the commissioners as opposed to tallying. The roles given, for example, to judges are known to adjudicate over matters. If it were to happen, and I know it can never happen, that the Chief Justice assigns judges some to go and receive advocates, some to go and receive VIPs, some to go and receive the media, then the Chief Justice remains with only 2 other judges, and they make a decision and tell the people of Kenya, this is the decision of the Supreme Court of Kenya. How absurd will it be? That is what transpired in this particular case. Commissioners were relegated outside their core functions, and the function performed by an individual, what I call a minority of the IEBC. That was never the intention of the law. On the technological aspect, as I move to summarize, I want to refer, my lords and my ladies, that's issue number one, on the qualitative test of the technology. IEBC, under the Elections General Technology Regulations, conducted an independent audit of the biometric voter register. This is what your auditors said at page 32, volume 1 of my bundle of documents. The KPMG report found that 481,711 persons were not qualified to be on the register, but they were on the register. Duplicates. One person has several entries. If this number was below the margin of victory, it will be insignificant. The start of an election process is the voter register. It must be a very clean document. In this case, they started the race with a register by their own audit as at the 16th of June. The register that was gazetted on the 20th of June, that register had 481,711 persons who were not supposed to be there. Duplicates, several entries. The margin of victory by which William Ruto passes 50% plus 1 is less than 70,000 within this margin. The margin of victory by which is declared more than Raila Odinga, 200,000, again less than this. So the universe of the elections was already compromised ab initio, and the number by which it is compromised could affect and did affect the results. To use my Supreme Court example, I will say, if all the judges were biometrically registered, we know there are 7 judges, but we go a biometrics audit, we find there are 9 voters in that register. Would we say that that register is authentic? If they were to vote on an issue, and then the return is 4-3, and yet the register had 9 people, would we say that only those who are legitimately qualified to vote participated? I will say not. In page 36 of my volume 1, the audit report finds that 638,814 entries were noted to be null IDs. You have registered voters on the register who don't have ID numbers. Null. That is the quality of your election document. And at page 37, the auditors find that there are generic users who cannot be attached to anyone. Generic users of the biometric voter register system who cannot be attributed to anyone. But more importantly, the auditors found that there were 14 non-returning officers, users, accounts that had been granted voter access privileges on the identity data management system. Non-users, some of them are referred to as Embakasi South clerks. People who had access to the system and they were able to make changes on the persons who are supposed to be on the register. Non-authorized users, their own document. At page 39, audit report finds that there are users who are not gazetted returning officers that have access to the database. It is important that we note this. Page 42, IBC's response to the audit queries. They said it was not humanly possible within the time available to deduplicate the register. That is, to remove those erroneous entries. So they are confirming they went into an election in which the register was compromised, and the number by which it is compromised could and did affect the results. They also purport to say that they cleaned the unauthorized users. At the time when they're doing it, your system has been compromised. There's nothing left to say. You are now running on autopilot, as the KPMG audit report says. The horse has bolted. The stable is broken. My lords and my ladies, it is my submission that when you look at the systemic issues arising and affecting the integrity of this election, should we even pay attention to the numbers which we are now being fronted? If the system was compromised from the beginning, the universe of the elections had been compromised from the beginning, that whatever numbers will come out of that universe of the elections, the voter register, does not matter. And I do believe even the third respondent, if he was the one filing this petition, would raise the same issues that I am raising today. What should we do in regard in terms of my reliefs? I urge my lords and my ladies, the problems of IEBC and specifically the second respondent are systemic, as I've said. The court should consider the conduct of this second respondent, Wafula Chebukati, and Professor Gulie and Mr. Molu. The common constant, they were the only commissioners who were in the 2017 general elections. They are the only commissioners who procured the elections technology. And they are the only commissioners again today who are dissenting. They are the minority commissioners who are trying to countermand a decision of the commission. Appropriate sanctions need to arise. In light of the disobedience of the court orders in Maina Kiai, the court was very emphatic on what is the role of IEBC and what is the role of the chairperson. Very clear. When he unilaterally ignores that court order, I urge this court to take that into account when making appropriate sanctions. When the same person in 2017, again, refused to accede to the orders of this honorable court in petition 1 of 2017, this court should take that into account. We can't be coming back to you every election with the same problem involving the same person. It is time that Mr. Chebukati is shown that the will of the people of Kenya is supreme and he must work within the constitution and decisions by this court. That's why we are calling for criminal sanctions and appropriate reports to the DPP. Why should the people suffer constant anxiety around elections that are being bungled when the courts have sounded themselves hoarse and loud on what is your role, what are you supposed to do, what technology to deploy, how to protect that technology, and is not doing it? If you look at we've attached the PSC report, Public Accounts Committee reports, again, finds an indictment of the same person sitting in meetings where he's conflicted. Look at the KPMG report. The auditors are saying they are being given even the information requested so late in the day, on the 16th of June, for a register to be gazetted on the 20th of June. This was deliberate attempt to make sure that the election is compromised. Section 6 of the Elections Act required the register to be opened for inspection 90 days before the date, the notice of a general election. The notice came out on the 20th of January. The register ought to have been opened 90 days before the 20th of January for inspection. He didn't do it. He gave the auditors the report so late, but they still pointed out that your register has a problem, and he took no remedial action. He proceeded to conduct the elections in the way that he desired. What he ended up doing is what my grandmother, Sophia Magambo, calls Nairobi Karafu, Pata Potea. Nairobi Karafu to mean at the National Tallying Center. It is, and we've averted on our feed of it, the national person of the commission called both Raila Odinga and William Ruto. The whole day, nobody knew who the winner was. Even the commissioners didn't know the results because tallying had stopped. I refer to the affidavit of the 11th respondents. They have confirmed even them, they were concerned. Why has the open display stopped? Why are you not announcing the results per constituency as you were doing before? That is what I'm saying my grandmother calls Nairobi Karafu. And my niece Mimi calls Piki Piki Ponki Pakamielo Disco. Because he called both of them. He called both of them. And he was the only person who knew who the disco would land on. It could have been either of them. It could have been William Ruto, it could have been Raila Odinga. It fell on William Ruto and he says, voila, you are the president. Is that how we intend to choose our national executive? We've reduced it to Mimi's childhood game of Piki Piki Ponki Pakamielo Disco.
Council again.
Yes, my lord.
I did give you brotherly advice. Be careful. That language appears to be alien to this court.
I'll be guided, my lord, I'll be guided. But the main point, so that we don't lose the crux of the point, is that the lack of transparency in the tallying and verification of the results, contrary to Article 10 of our Constitution, completely eroded public confidence in our Constitution. It completely left a very core exercise of a sovereign donation by the people to the whims of an individual not subject to any control. And that, my lords and my ladies, should not miss the attention of this court. My lords, in our submissions, we've spoken about the DCI report and the penetration of the system. Again, just to buttress the role of this chairperson. My lord, the DCI, as has been submitted, is set up as a government agency to investigate crime. They did find that indeed there were foreigners who had access to what we call critical election instruments. And their forensic report has established the presence of those persons. In other words, in layman's language, the DCI report has corroborated what the KPMG report has found and authorized users and access to critical elections technology. Should we ignore that and say, just look at the numbers, forget about the process? I humbly submit that we cannot now even focus on the numbers. We should not even, because the process through which those numbers are being arrived at has been compromised. So that anybody inviting you even to look at the number is inviting you down an alley, a process in which the wish of the people has been convoluted. My learned senior John Mohammed, representing a poor voter, did say that voter just wants to see, just wants to know, how was my vote converted into account and the result of the elections. If the infrastructure and the process set up for that poor voter does not guarantee integrity, then, my lords and my ladies, it is my humble submission that the number that an individual ultimately comes out with at the end does not matter. If that number comes out in a manner that infringes the Constitution, you've come up with your number in a manner that violates specific provisions of the Constitution, then that number does not matter. The Constitution has to be upheld. Because the Constitution is what established the framework through which we will start generating that number. You ignore the Constitution, then it doesn't matter. We've not organized ourselves as a sovereign on how to arrive at the number. My lords, as I move to conclude, I think it is very important that I buttress this point on the meaning of Article 138.3c, because I see I still have 4 more minutes and I will not wish to donate them at the moment, and Article 138.10. The IEBC shall tally and verify the count and declare the result. That's the first step. And I've invited the Honorable Court, there are numerous decisions from these courts on what a result is, outcome. So the first declaration to take ownership of the elections is done by the IEBC once they've verified and tallied the count. And some of the tools of verification, number one are the KIMS kits, because the KIMS kits were meant to send you voter turnout per polling station. So part of how you verify, you ask yourself, this particular polling station, as per the KIMS kits, how many voters logged in? Thank you. How many voters logged in and voted in that polling station? Once you establish that, you check on the Form 34As, how many registered voters are entered to have voted in that station. If the numbers are different, then you ask for Form 32A, assuming some were identified manually. Those are the steps of verification. But if the numbers in your KIMS kits are less than the numbers of the votes returned and are not supported by any Forms 32As, then that's a polling station to be flagged. It means the verification has not returned or cleared that polling station. That is what the IEBC does. Verification is not, as they're trying to attempt to tell us, is about looking at the UV mark, looking at the serial number. Those are just part of verification. But the verification, number one, is to identify that indeed the true universe came out and voted. And that is very important. It satisfies itself. We go to Article 138.10, in which Article 138.10, the chairman now walks out of the commission meeting together with all his commissioners, if necessary, and proceeds to now declare the result. Because remember what I said, the first declaration was done by the IEBC when they concluded their verification and tallying. Then the other declaration, 138.10, is done by the chairperson. And then he issues the certificate as an individual. So that to assume that the chairperson on his own can conduct, or that the staff of the commission are the ones to do the tallying and verification, that is erroneous. It is the commission that does it. The staff of the commission are spread everywhere. They report to the commissioners who constitute the commission. And the commissioners take control of that process. And finally, my lords and my ladies, it is not the first time we are holding elections in this country. To say that Mr. Chebukati didn't know what the law was. He knew. These provisions have been applied in 2013. They were applied in 2017-1 and 2017-2. And the commission functioned as a commission to conduct those elections. Why should we now move away? My lords, finally, in this election, we submit the people had their say, but the machines, technology, had its way. Please correct it. Thank you very much. Have a good day.
Petition number 4 of 2022, David Kariuki Ngari.
My lady, this is petitioner number 5 in the consolidated petition. My name is Metuga. I will deal with issue number 6 as framed by the court, My colleague, Mr. Njirundewa, will deal with issue number 8. The petition is dated 22nd of August 2022. We have filed submissions dated 25th of August.
Counsel, let us confirm. Who is your client?
My client is David Karaoke Ngari.
Ngari.
Yes.
Then according to our records, it's number 4, petition number 4.
I do apologize, my lord. It would appear I printed some ruling that reflected him as petitioner number 5
okay. Maybe
in the
after
consolidated petition.
After the consolidation, yes.
Yes.
The party is the same, no problem.
Very well, my lady. We have filed petitioner submissions dated 25th of August 2022. They are supplementary submissions dated 28th of August 2020.
Sorry, you said that you'll address issue number?
I will address issue number 6.
And Mr.
Ndewa will address issue number 8.
Correct, thank you.
My lord, we have filed submissions dated 25th of August 2022. We have supplementary submissions dated 28th of August 2022. My lord, there is a quote attributed to the American statesman Harry Truman that the president, whoever he is, has to decide. He cannot pass the buck to anybody. No one else can do the deciding for him. This is his job. And my lord, it is my submission that constitutional mandates given to IEBC have to be performed by IEBC because the buck stops with the commission. Our constitution has been characterized as a transformative charter. My lord, the only way it can be a transformative charter is if we breathe life to it instead of paying lip service. The principles that run through the Constitution, including transparency, accountability, participation of the people, have to be given. We have to breathe life to those provisions if the Constitution has to live up to its characterization as a transformative charter. It can also live to its characterization as such if the independent institutions under the Constitution discharge their mandates according to what is provided there. One of the institutions is IEBC. Under Chapter 15 of the Constitution, it has a critical function which is captured under Article 249A. It must protect the sovereignty of the people. And one of the ways it protects the sovereignty of the people is to ensure that the will of the people in electing their representatives reflects what the people have voted it to be. This is because, my lord, sovereignty is exercised directly. It can also be exercised by the representatives they elect. So by sticking to the principles that guide the process of election, that's how it can give the sovereignty of the people the life it deserves. Under Article 81 and Article 86, the electoral process has to observe, among other principles, transparency. It also has to be an accountable process. My lords, the commission is constituted under Article 88 And the national legislation that provides for the commission is the Independent Electoral and Boundary Commission, that is Act number 9 of 2011. Under Section 5, a commission is established, and under Section 11 and 11A, it's categorical that the Secretariat works under the commission. So the staff of the commission performs a delegated function. The buck stops with the commission. My plain reading of Article 138(3)(c) is that the process of tallying, verification, and declaration of the result is the mandate of the commission. It's not the mandate of the staff or the secretariat. This is also reiterated under Section 39, 1C, paragraph B, which also states categorically that the function of tallying and verification is supposed to be done by the commission. Was it done by the commission? That is the only question, my Lord, I will answer. I will answer it through the eyes of the averments made by the 9th respondent, that is Professor Abdi Gulia, and the 4th respondent, that's in the consolidated petition, that's Honorable the Chairman Chebukati. This is how, from their own affidavit, without even going to the regulations in which they set out on how the verification was supposed to be done, from their own affidavits. When the other 4 commissioners are clear that they were not involved in the verification and tallying and declaration of the result, this is what they say in their respective affidavits. The affidavit of Professor Gulia, the 9th respondent, sworn on 20th of August 2022 in respect of petition 005, at paragraph 8, he is clear that once assigned a responsibility by the commission, whatever recommendations he makes have to go back to the commission for consideration. So from his own averment, it was clear that even when the commission delegates a function to a commissioner, he has to report back to the commission for approval. At paragraph 32 of his affidavit, this is how he described how verification was done and the result generated. That the chief executive officer / the commission secretary came with the final result. That is on 15th of August 2022, when the commissioners were seated in a meeting. He acknowledges that the verification is not being done by the commission. It is the chief executive officer getting to the commissioners a result, a clear admission that they were not involved in the tallying and the verification of the result. Now, in respect of the 27 constituencies which have been mentioned, and there was doubt whether verification was done, this is how he puts it in paragraph 27, paragraph 35 of his affidavit, that these constituencies were verified in the presence of agents of candidates and included in the final tally. There's nowhere in that statement he says that verification was done by the commission. Now, on why he did not even announce the result for transparency, then he says there was no there was no calmness in the auditorium for them to announce the result. But then the question is, when it was restored, the chairman of the Electoral Commission was able to read the result in Form 34C. The question is, during that period, how is it that they could not result for the 27 constituencies? The chairman of the commission, Honorable Chebukati, in his replying affidavit to the fourth petitioner's petition, the affidavit is undated, but it was filed on 27th of August 2022. This is how he characterizes the verification of the result by the commission. At paragraph 31, he avers under oath that the verification and tallying was undertaken by a staff of IEBC with some commissioners assigned the role. My Lord, from the chairman's own averment, the verification is being done by a commissioner assigned the role, and the staff of IEBC. There is no indication anywhere that that outcome of the verification was brought before the commissioners before an announcement was made. It is understandable that tallying and a verification 40,000 polling station is an Herculean task, and it cannot be done by 7 commissioners. But, my lords, if they delegate that function to the staff of IEBC and a commissioner or 2 commissioners, it is my submission that whatever report that comes out of that tallying and verification has to be placed before the commissioners before a declaration is made. My Lord, that was not done. Now, an explanation is given by the chairman of the commission at paragraph 25 of his affidavit in reply to the fourth petitioner's petition, when the fourth petitioner avers that no announcement was made for 27 other constituencies for purposes of transparency, this is what he responds: there was no legal obligation to do that. My Lord, there is no explanation given why it was done in respect of 261 other constituencies and not the 27 constituencies. It's my submission that in respect of those other 27 constituencies, there was lack of transparency and accountability. The chairman avers in that paragraph 25 of his affidavit further that Professor Gulier was prevented from reading the results, but there is no explanation further why he could not read the result for the 27 constituencies after calm was restored. And if at all tallying was already done for the 27 constituencies and a report prepared, my lords, this should have been included in the reply of the chairman to the petition to confirm that indeed the tallying and the verification had already been done. It's my final submission that the result that was declared by the chairman of the commission did not reflect the will of Kenyans, and it should not be let to stand. My colleague will take over the issue number 8. Thank you, my lord.
My ladies, my lords, my name is Dego Anjiru, permit me to address issue number 8 in respect to our petition. And while addressing that issue, my ladies, my lords, I'll be seeking to answer the question whether or not the election that was conducted on 9th of August was a constitutional election. While I do that, my ladies, my lords, permit me to refer you to various affidavits, and I begin by referring to paragraph 52, paragraph 53, and paragraph 54 of our petition. I'll also refer to paragraph 51 of the Vice Chair's replying affidavit, that's the 5th respondent. I'll also refer to paragraph 25 of the Chairman's Chebukati's replying affidavit. I'll finally look at paragraph 19 of the second respondent's, William Samoei Ruto's affidavit. Why are these paragraphs important to these proceedings, my ladies, my lords? And while addressing that question, I am going to refer to various provisions of the Constitution. I'll begin by referring to Article 88 of the Constitution. I'll seek reliance again on Article 89, Article 97, Article 138, Clause 2. I'll also seek reliance on Section 2 of the Election Act, and I'll also seek reliance on Section 83 of the Election Act. My ladies, my lords, if you look at the affidavits that I have mentioned, and most importantly, affidavit by the chairman of the commission, at paragraph 25, he defines and says that he conducted tallying of election results in 291 constituencies. Paragraph 19 of Honorable William Ruto's affidavit, again he says that elections were conducted in 291 constituencies. The fundamental questions, my ladies, my lords, is how many constituencies do we have in this republic? If you look at Article 138, Clause 2, the Constitution provides that elections shall take place in each and every constituency in this Kenya. And when you define constituency, my ladies, my lords, you look at the provision of Article 4 and Article 5. Article 5 of the Constitution, which defines the territory of the Republic of Kenya. Then you further look at Article 89, Clause 1. It says there shall be 290 constituencies in the Republic of Kenya. And that is where the law contemplates that elections shall take place. But what happened on 9th of August is that we have submissions and averments that elections took place in 291 constituency. The fundamental questions, my ladies, my lord, is where did this extra constituency come from? And is this extra constituency a constitutional constituency defined by the armpits of Article 89? There may be arguments that this was a constituency by the diaspora. Yes, they may have their rights under Article 38 to vote. But the question is it a constituency within the meaning of the law? We submit that to the extent that individuals not confined to Article 89 of the Constitution, to the extent that the elections of an extra constituency not defined under Article 97 took place during that particular time, that contaminated the election. You must then ask yourself, to what extent was the contamination? Article 138, Clause 4 requires the Commission to compute whether or not the president-elect has attained 50+1%. We are submitting that these elections that took place in alien constituencies contributed to the computation of 50+1%. Then you might ask yourself, my ladies, my lords, what then is the test that I'm trying to apply? I am applying the test proposed by Section 83 of the Constitution of the Election Act. It provides that an election can be voided if that election did not comply with the Constitution or other written law. And this is a fundamental question, my ladies, my lords, because a constituency as defined by Article 289, Article 89, that must be within the territory of Kenya as defined by Article 5, then contemplates a situation whereby there is a question of representation. It subjects the people of Kenya to exercising their sovereignty through the representation of those people. The question then that begs an answer is, how can an election that has been infiltrated by alien constituencies be regarded as a constitutional election? We submit thus that waives the fundamental requirement where IBC under Article 88, Clause 5, is required to conduct an election within the armpits of the Constitution. It is a mandate within the IBC that the mandate is so fundamental that it cannot be waived, it cannot be fettered, it cannot even be relaxed. An individual cannot create a constituency. If it was in the interest of Kenyans, while promulgating this constitution and adopting this constitution and giving this constitution unto themselves to create an extra constituency, there was nothing that was as easy as saying as such. My ladies, my lords, permit me to address the question of the 27 constituencies. Again, it has been submitted by my learned friend that under paragraph 25 of the Chairman Chebukati's replying affidavit, he has glossed over that weighty issue. He does not consider that 27 constituencies, which makes about 10% of the Kenyan constituencies, which translates to about 1.9 elected voters, were not included in the final tally. And what does he do? He makes and he amends and carefully uses the words which to apply. In his replying affidavit, he technically avoids the use of the word declaration and he uses the word announcement. The word announcement is not akin, is not similar, and does not mean declaration. Why, my ladies, my lords? Because Article 138, Clause 4, presupposes a declaration of all the polling results by the IEBC. So this declaration is not akin to announcement. And therefore, my ladies, my lords, we are submitting that the chairman of the Electoral Commission was lost on what he needed to do. He is making a declaration and reducing the question of declaration to the question of a master of ceremony. The IBC chairman was not called upon to just officiate the process. He was called upon to execute a constitutional obligation. And therefore, when the law speaks about a declaration, there must be clear demonstration that the same was done. What happened, my ladies, my lords? He says that the law does not require him to do so. He does not annex any evidence that the same was declared. He does not annex any evidence in his affidavit that there was tallying. He does not aid this honorable court to make an opinion that yes, the requirements of the Constitution were met. Finally, my ladies, my lords, we need to interrogate the conduct of the chairman of the IBC. We need to interrogate the previous and even the current conduct of the chairman. He was effectively described by my senior line friend, Mr. Norji, that is a person who has perfected the art of imperfection. And he has perfected the art of imperfection by making sure that he conducts a lone ranger process. Remember, my ladies, my lords, to the run-up of the second election in 2017, a similar issue arose, which necessitated the resignation of the commissioners. How long shall we allow an individual to keep on transgressing the law? How long shall we allow this individual to keep on putting Kenyans and to subject Kenyans into uncertainty? The law requires that there must be certainty. And the certainty contemplated by the law is that I shall cast my vote, and my vote shall count. And where are the 27 constituencies fundamental and key to these proceedings? If you look at our paragraph 57, 52, 53, and 54, we have listed those constituencies. It is where an individual or the first petitioner has his supporters. It is where he has his support base. So were they left out as a matter of design? Were they left out by default? Or was he holding someone's brief? My ladies, my lords, we submit that to the extent that those constituencies were not tallied, were not verified, and the declarations were not made, then this election did not meet the provisions of the Constitution. Finally, my ladies, my lords, he says in paragraph 25 that he can announce elections anytime that he so wishes, even if there are some constituencies that have not generated their results. But what does section 39, subsection 2 of the Election Act provides? It provides, my ladies, my lords, I would wish to read this. The chairman may declare a candidate elected as president before all constituencies have transmitted their results. The operating word here, my ladies, my lords, is the word before. So if before, at the time he's declaring those elections, the constituencies have not generated their results, he can declare. But the situation where we are in, my ladies, my lords, on 9th, going by the dictates of Maina Kiai's case, the chairman had received all the results from the polling stations. It was therefore incumbent upon him to make sure that they are included, to make sure that they are tallied, to make sure that they are verified. Finally, my ladies, my lords, permit me to delve on an issue that was dealt with in the morning by my senior learned friend, Mr. Governor Orengo. My ladies, my lords, I am referring to the replying affidavit filed by Honorable William Ruto, and I'm referring to page 111, where it indicates a preliminary statement of the IGAD election observation mission to the August elections. At that paragraph, my ladies, my lords, these were individuals who are observers of the elections, who are out there observing the elections. When it came to the question of analyzing the voters' turnout, the report says, it is annexed in its affidavit, that in most of the polling stations visited, voters' turnout was noticeably low and recorded around 55%. Those were observers out there in the field observing the elections, giving a return of the 55%. And this 55%, and you can see how this computation of the turnout is fluid. It is so fluid. It's a lever. You are not able to hold it. The chairman is not able to tell about the voter turnout. The report is giving us a different voter turnout. So what exactly was the voter turnout? So that the voter turnout then can assist us in the computation of the sum of 50 plus 1%. Finally, my ladies, my lords, there's a question as to the computation of the 50 plus 1%. That when the chairman gave his final public address about the voters' turnout, he deliberately exempted those individuals who voted manually. To date, we are not aware of how many people passed through the manual registration. How many people voted manually? I mean, my ladies, my lords, it is not within the armpit or within the purview or within the power or the discretion of the chairman of the Electoral Commission to do that what he wishes. He cannot deal with the question of elections from his aspirations or from his wishes. He must deal with the question of election as dictated by the Constitution, as dictated by the election laws. Finally, my ladies, my lords, we urge you to admit our petition and you dismiss the replies filed by all the respondents and find that this election was not conducted in accordance to the Constitution. And my ladies, my lords, that you give an order that the sovereignty of the people must be respected. And the sovereignty of the people cannot be respected, cannot be upheld where there is serious transgression at the wishes of the chairman of the Electoral Commission. Finally, my ladies, my lords, there needs to be a retribution. There needs to be a stop of all these transgressions. How many times shall we subject Kenyans to these processes? How many times should we appear before you with the same grievance every day, after every elections? There ought to be a stop. And a stop is making sure that the proper sanctions, criminal sanctions, as prescribed by the Election Act, are meted against any transgressor. And there is no one who is above the law, including the chairman, so that people may learn to respect the law. I'm so obliged. I donate the 26 minutes to the court.
Thank you very much.
Seconds.
Those are seconds. Thank you very much, Council. As regards petition number 7, we have Mr. Omtata appearing for himself, and Professor is appearing for the other. So I think you'll share the time, Prof.
Thank you, Your Ladyship. Well, our submissions will be in two parts. The first part will be qualitative, and I will address myself to the law and complement the submissions that have been made by learned friend, Senior Counsel James Orengo, learned friend, Senior Counsel Philip Mulgor, and Feroz Noroji, on the questions of compliance with the law and on the unconstitutional nature and the non-compliant nature that the first respondent, Mr. Chebukati, employed in running the presidential election of 9th August 2022. My lords, the person I would not want to be now is Professor Githu Muigai, because every single advocate in this court has spoken to the violations by his client. Violations, my lords, that border on the violation and speak to the violation of Article 3.2, the unconstitutional proceedings that led to the issuance of Gazette Notice 9773 of 2022, issued on 16th August 2022, that declared the president-elect. My lords, we shall be asking that that violation of that Gazette Notice be vacated as we make several orders, my lords, under Section 84 of the Elections Act and Article 143 of the Constitution. My lords and my ladies, let me start by submitting that my submission shall be around one, the issues framed by the court, particularly, my lords, issue number 8 on illegalities and irregularities that, if applied disjunctively as this court has ordained before, my lords, will lead to a compelling order of nullification of the elections of 9th of August 2022. But I will also, my lords, and in view of the powers of this court under Section 3 of the Supreme Court Act, delve into the interpretation of Article 143. And my lord, perhaps because this court is also the jurisprudential head of the judiciary, to see, my lords, whether there are possible sanctions or possible findings that this court can make other than the order. And my lord, that will be in my last submission. My lord, let me just touch on the second part. The second part that my learned friend Mr. Omtata will deal with will be the maths, electoral maths, the mathematics of the election. We will demonstrate by way of a PowerPoint presentation that none of the candidates met the 50% plus one vote as per the tallies that were read by Chairman Chebukati on the percentages weighed against the voter turnout and the votes cast, my lords. And that will show that if indeed no candidate attained the 50% plus one, then this court has a daunting task. One, of course, after the exercise that is ongoing, the exercise that is going on with the server, my lords, we will be asking this court, my lord, to think of the possibility of declaring a winner after the outcome of the access to the back end of the server. That's number one. But number two, my lords, patently, the results announced by the chairman of the IEBC were unconstitutional because they did not emerge from the commission. And granted, my lord, that they were unconstitutional, if the court then is unable to arrive at a result as to who won the election, my lord, then of necessity the court would then would have no option but to proceed to nullify or find that it was conducted illegally. My lord, let me just proceed because of time to the key submissions. My lord, it is patent and glaring that there was non-compliance with Article 81A and D of the Constitution, read together with Article 86E of the Constitution. The elections were not verifiable in as much as voting took place. The process of tallying of the presidential vote from the polling station and the issuance of Forms 34As transmitted to the constituency tallying center and finally to the National Tallying Center, my lords, was not a verifiable process. My learned friend Philip Murgod has spoken largely to the access that two individuals had to the system. He had spoken of one Dahir and one Kwanusu who had access over 1,000 times Mr. Kwanusu, the PA to the chairman, Mr. Professor Gidhu's client. Clearly, my lords,
I would like to request the Honorable Court that we conduct this petition in the tradition, in the very long honored tradition of each counsel arguing his case without any sideshow.
My lord, it is a fact that the chairman is Professor Gidhu's client, but I will, because of the discomfort, address myself to
Yes, I'm speaking.
Yes, my lord.
I think you should treat your colleagues with respect. We all know that who is representing who. So make your point.
My lords, I will proceed. I will proceed. I will not mention Prof's name going forth. But my lords, the violation is glaring in view, my lord, of the fact that the non-verifiability of the process from the tallying center as held by the Court of Appeal, my lord, we've spoken to this severally, to the National Tallying Center of what each presidential candidate received, my lord, is a subject of an unconstitutional act. My lord, that is point number one. My lord, therefore, the counting, there was a violation of the duty to count each vote cast by an individual as contained in the Form 34A transmitted to the National Tallying Center and as uploaded to the Form 34Bs and 34C that was used to declare the result in Form 34D, my lords. My lords, granted further, that violation is also reflected, my lord, in the violation of the Elections Act itself. Because, my lord, there was a requirement that once the tallying is done and the verification done under Article 138(3)(c, it was not the chairman but the commission that was required to undertake that process. And my Lord, I want to speak to the affidavit of the chairman himself. Other advocates have submitted on the self-importance that the chairman presumed in conducting the final tally, ignoring the mandatory nature of Article 138(3)(c. This court has dealt with the question of interpretation of statutes and of the Constitution, my Lord, where there's a compelling word, shall. Article 138(3)(c is compelling in nature. It does not give the chairman an option of consultation or of assuming the role of the commission. It states, my Lord, that the commission shall undertake the process, not the chairman. The same term, my Lord, is used in the second schedule to the IBC Act and in sections 4 and 8 of the Elections Act. My Lord, if I may just read 138(3)(c. It provides, my Lord, that the process of tallying, my Lord, after counting the votes in the polling station, the independent electoral and our commission shall tally. My Lord, where shall is used before a verb, citing my learned friend, senior counsel, it leads to an inevitable and compelling option. And this is what the courts have interpreted in several cases that we have handed over to the court, my Lord. The cases in Kirain Investments and National Land Commission, this was the finding of the court, again citing the findings of the Court of Appeal on the same question. Wesley, Judge of Appeal, laying down the consequence of the use of the word shall as peremptory. So, my Lord, that of itself, any action reflected in the affidavit of Wafula Chebukati that denotes any action by himself in assigning other members work, my Lord, and in eventually purporting to act under 138(10) alone without consultation, invalidates the entire result that he purported to announce and invalidates the issuance of Form 34C and D, in which he purported to announce the results of the election. My Lord, ipso facto, the duty to transmit, tally, and collate was therefore violated. The regulations, my Lord, 39(1)(c) of the Elections Act required two tallies, the physical tally and the electronic tally that ought to have been transmitted. Non-compliance, my Lord, is evidenced in the affidavit filed by Cherere and by the four commissioners, my Lord, and an admission by the chairman himself that the tally was not compliant with section 39(1)(d) of the Elections Act. My Lord, going forth, the complementary nature of compliance reflected from sections 39 to section 44 uppercase A of the Elections Act, my Lord, denotes non-compliance by the commission, but also an admission, my Lord, that there was no commission the moment the commission was divided and was working in different forms. My Lord, Article 3(2) of the Constitution provides that there shall be no government established other than through the Constitution, so that any violation that leads to an unlawful process, my Lord, cannot stand. And this court has the duty under Section 3 and Article 140 to invalidate an offensive action that is unconstitutional. My lords, we submit that through the affidavits that admit the interference with the transmission system, the interference with verification, and the duty to declare the presidential election by the Commission, the result gazetted in Gazette Notice issued by the chairman, being Gazette Notice 9773 of 2022, was unconstitutional and cannot stand and must be invalidated by this court. My lord, in view of time, we wish to submit that even aside finding that even the duty of the Commission as created and enshrined, my lords, in Article 249, is governed and dictated by the principles under Article 10, my lords. And my lords, where public officers do not act in a manner donated by Article 10, then their actions must be vitiated by the court. And this is the forum where such actions must be vitiated. My lords, the law is clear. The maxim ex turpi causa non oritur action, which has been developed over the years, my lord, by Lord Mansfield, initially in Holzman versus Johnson, later in Tinsley and Milligan, and now in Patel versus Mizra, speak to the fact that no circumstance can allow this action to stand. The opposing affidavits, my lord, the opposing affidavits filed by the 4 commissioners and the 3 that speak to the violation of paragraphs 5 and 7 of Schedule 2 can only lead this court compellably, my lord, to find that this is a matter that this court must handle in the manner that lex arbitri would dictate. My lord, this the principle ex equo et bono used by international tribunals to settle questions. In the local framework, my lord, we refer to Solomonic wisdom in 1 Kings 14. The court should look at the opposing affidavits. The court should look at the misconduct of the chairman of the commission. The court will then compellably apply the dictates of fairness in this matter and find that the people of Kenya were violated by the conduct of an election outside the framework of the Constitution, through the violation of the process, through the violation of the outcome. And my lord, we want to demonstrate to the court, before I wind up, that mathematically, and this is where the law meets mathematics, no candidate attained the 50%. If the chairman read the results that he read and the percentages that he read out of the registered voters that cast their votes, my lord. My lords, the maxim amiable compositeur that I shall look at after my learned friend Mr. Omtata presents the results, my lord, will show you that this court has no option but to nullify this election. There's no option. There's no option. Mr. Omtata.
Gather because you're all senators, you're learning friends now?
Yes, my lord, Mr. Omtata is a serial litigator and a public interest, a public defender in this country. And I respect him for that role, my lords.
And now a senator? And now he's a senator?
Yeah, he's a senator for Busia County. He replaced the Attorney General, who did not run for office.
Members of the Honorable Court, in my submissions, I will rely on the petition we filed jointly with the three others. It's dated 22nd of August. I also have submissions which I filed alone, which are dated 26th of August. And I also have a further affidavit, which is dated the 29th of August. My lords, before I remark on the mathematics, I just wanted to make a small observation as regards point number 1. And I think the elephant in the room is point number 1. What kind of election does the Constitution of Kenya anticipate? That's a question that I've seen documents and videos by some members of the court telling me that even this court does not comprehend the kind of election anticipated under Article 81 and 86 of the Constitution. Short of a digital election, you cannot meet the constitutional threshold.
Mr. Mutata, what
Yes.
did you say?
I said I've come across publications and video recordings by some members of the bench who complain that the 14 days the court is given to determine a dispute concerning the presidential election is too short. And I'm saying that statement demonstrates the failure of, with due respect, the honorable judges of this court to understand the electoral architecture in the Constitution of Kenya 2010. The Constitution of Kenya 2010 only anticipates a digital election. And if we are dealing with a digital election, 14 days is too much. But if you are dealing with a paper election, a manual election, you need maybe 2 months. That's where I wanted to begin. And this election does not meet the threshold in the Constitution at all. The presidential election, the one I'm referring to, that's before this court. It's not simple. That's why you have got spoiled ballots. In a digital election, you don't have spoiled ballots or rejected ballots. And you don't even have the question of whether the spoiled or rejected ballots count. It's not verifiable. Right now, I cannot verify where the ballots I cast went. I don't know. The moment I dropped them in that box, I lost all contact with those ballots. There's no mechanism of verifying. A digital election would give me a serial number by which I could track my ballots. So I'm saying that if you look at the threshold in the Constitution, we must work towards a digital election and move away from these paper elections, which allow human interference without sometimes leaving footprints. I would now go to my submissions. I was supposed to be given some aid. Yes. Where the...
If the time could stop running, we had supplied the electronic instruments to the court.
You guide the assistant.
I don't understand what you said. I come there. Oh, open for me the PowerPoint document. Go to the next slide. Yes, we're looking at an analysis of paragraph 26 of affidavit filed by Mr. Sunkuli in petition number 7, paragraph 226. And you can see that he's giving us, he gives data of how the KIMS kits transmitted on 9th August at 17 hours at the close of polls. He gives that figure. On 9th August at 20:45 hours, about some 3 hours and 45 minutes, he gives his figure of 13 million. Then, most surprisingly, you have two entries. There's the entry that which gives us at 14 hours and 14:40 hours. The KIMS kits are transmitting some 23 hours later, still transmitting data. And we're saying that that data is not acceptable. So we come to the next slide. I'll just run through given the short time I have. When you got that slide, you look, they tell you at 20:45 hours, on 9th August 2022, some 13,731,215 people voted. Polling turnout recorded on 10th August is 14,239,862 ballots. And on the 10th, that is the day after the voting, and we know that it's only elders where elections were taking place. Now, when you analyze that data, you find that 508,647 ballots are added on the 10th. And you saw Land Council Willis show that the audit of the register had almost the same number of ghost voters. So you can see from that data that Mr. Sunguli presents, you are able to isolate 508,647 ghost cast votes, which are more than the difference between the two leading candidates. We've got the next slide. And if you look at the ballots that are recorded to have received, to have recorded on the next day, we are talking of some 1,665,412 curiously cast votes, which are coming out after the close of voting, and that's after 3 hours after the close of voting. So if we take the total tally now, you find that the tally is close to it's about 1.7 million votes. That spike in votes is not possible. That spike in votes is part of the problems we're having, that fellows were having access, the KIMS kits that were still transmitting data from locations that are not clear. Because the KIMS kits that were in polling stations, the voting stopped on 9th. And giving an allowance of 3 hours or 4 hours for people who are still on the queue, you would understand by why Akim's kit would still be transmitting 23 hours after the close of elections is something that is difficult to comprehend. Also, my members of the Honorable Court, if you look at the Form 34C that has been published and interrogate the data there, if you look at the total of the variables ascribed to each candidate, the amount that you get is 110 votes less than the number that has been printed on that paper. Now, if you look at, that thing was boggling my mind. Initially, I thought it was a simple error of addition. But just come out, it was not a question of 1 + 1 = 3. Because when you look at paragraph 32 of the replying affidavit of Mr. Sunkuli, yes, I'm on, yes, go to the next slide. Next. Yes, sorry, I forgot to, thank you for directing me. If you look at paragraph 32 of the replying affidavit of Mr. Sunkuli, the total voter turnout in the table when you subtract from it, as given in the table, the number of rejected votes on Form 34, you get exactly that figure of 14,213,137, which in their replying affidavit they claim was an error of addition. But if you interrogate their raw data, you find that that figure is the valid figure. So the votes attributed to the candidates are fictitious. From paragraph 32 of Mr. Sunkuli's replying affidavit. So, when you go on to the next slide, I've reproduced I've tried to factor in the figure that Mr. Sunkuli gives, and when you add them, you get the 14,213,137. Yet, when you add the figures attributed to the individual candidates on Form 34C, they come to 14,213,027. That is not an innocent mistake. It is a situation whereby somebody has left a trail that they were working backwards from a certain figure which they had, and they were working backwards, and so they would going to get that. And most important, I would also refer to the affidavit signed by the chairman, filed by the chairman in petition number 5. At paragraph 95 of his replying affidavit, sworn on 26 August 2022, the chairman presents the exact figure of 14,213,137 as the total valid votes cast for all the 4 candidates. So if that is the figure that's coming from the raw data, that's the figure that's carried in the affidavit, then the values attributed to each one of the 4 candidates are fictitious and cannot count. And therefore, that Form 34C is an invalid document. Go to the next slide. Sorry, next. Yes, so in that slide I'm saying, we can only conclude that these figures, which form the content of Form 34C, are cooked. You cannot have both of them in the same document. And this court should not allow that document to stand at all. And the conflicting figures and those conflicting figures for valid votes cast of 14,213,137, and the other one is the one when you add the values of the individual candidates, the 4 candidates, you get 14,213,027, is evidence that the results were worked backwards to achieve a desired or predetermined outcome. Therefore, the declared percentages for the 4 candidates, no, the votes attributed to the 4 candidates and the declared and the percentages attributed to them is all fiction. Now, I got to address the question of whether you can achieve, if assuming that what in the totality of the announcements made by the chairman, any of the candidates realized 50% plus 1 vote.
Just checking on the time.
Yes. There's no display for the time, unfortunately.
According to mine, time is over. If you could just finish your slides.
Okay, thank you.
Because they seem to have lost theirs.
Okay, so a further analysis of Form 34C on voter turnout, the chairman announced, and that issue has not been retracted at the close of voting. He was answering a particular question, and a journalist asked him, as matters stand now, what is the national voter turnout? And he said, oh, that one, I can deal with it. And he said, as at the time he was announcing, it was 65.4%. And according to what the KIMS kits had reported. And he expected that value to go up when all the KIMS kits had reported and the manual had been included in it. So when you calculate that against the total voter register, the national voter register of 22,120,458 votes, you get that the voter turnout as at that time was 14,466,799 votes. The next slide. So from Form 34, the tallies are ascribed on Form 34. You get, when you factor in the rejected votes, you get a total value of 14 million votes having been cast. That is the valid plus the rejected votes. So when you get the difference between the two, the declared voter amount and what has finally been published in Form 34C, you find that a number of 140,138 votes were not accounted for. To the attributes given to each candidate, because we are now ignoring the number published on Form 34C that are claiming was a mistake, but which I've demonstrated was not a mistake. Now, if you factor that number of the correct number of the additions, which is 14,213,027 plus 140,138 votes, you get 14,353,165. Using that as the denominator, you get that William Ruto gets 49.99692402%. And the reason we are going to doing these decimal numbers in the long form and not reducing them, because the winning vote is 1. And what's the percentage of 1 in 14 million votes? It's about 7 zeros before you get to any digit. So that's why we are keeping the long form. So when you when you round it off, you kill voters and you include new voters. So Raila gets 48.372118662. The next page, Wahiga would get 31,987, which would translate to 0.222856771%. Wajakoya at 61,969 becomes 0.4317447. And so now there are these other votes, the 140,000 votes, 140,138 votes. Since those votes were not, we don't know how the voters gave them to the candidates. We cannot randomly allocate them to any candidates. So they become the fifth variable here. Those ones amount to 0.976356086%. In the scenario, no candidate acquires 50% plus one vote. That is required under Article 138.4, 138 Clause 4, Paragraph A. And so, with those few remarks, I pray that the Honorable Court allows the petition and the other petitions, and then...
My Lords, I had intended to make the prayers in view of the jurisprudential weight of the mundane questions that I would want this court to
sorry, Senior Counsel. Can Mr. Omutata confirm? I'm trying to go through the record. This PowerPoint presentation you've just made, is it part of your pleadings?
Yeah, it's part of my pleadings in the...
Word for word?
Yes, word for word. But I'm just cutting for purpose of highlighting.
Okay, thank you. Unless you are changing, that is not word for word.
No, it's word
So if it's word for word, we don't need any other copy.
But of the most important is the further affidavit, because when I did the first one, I did the petition, I did not have the information that came from... I did not have the information that came from Mr. Sunguli's affidavit. So I would request the court to pay particular attention to the further affidavit. That's why I had the benefit to compute the figures with the figures that the commission supplied. That's all, my lord.
Thank you.
Compelling are the figures that finally mathematics finds its way into invalidating a
So, General, you have no
election.
leave to address the court after time. Why don't you start from there? From where? From what time? Start from there.
Just make prayers.
Senior Counsel, we agreed on the ground rules yesterday. Your time is up. In fact, his time went over because he was on the PowerPoint. We noted he went over by 6 minutes. So please, yes, if you have anything, you can reply when you have time to reply. Rejoinder. I will now invite counsel in petition number 6, Njuria Yokabichege and others.
It is petition 8 after consolidation.
Yeah, it is 8 after consolidation, yes. It's petition number 8.
May it please, Madam Chief Justice, Deputy Chief Justice, and other members of the court. My name is Kibe Mongai, appearing with Ms. Wairi Mukeru for Julia Nyokafishege and 3 others. First of all, let me say that I'm very happy to be responding last, and particularly to have had that very good presentation by my long-term friend, Mr. Okiya Omutata. My Lord,
and my ladies, the petition before the court has been introduced. The petition is dated 22nd of August this year. It is supported by two affidavits, an affidavit sworn on 22nd of August by Julia Shege, and a further affidavit that she swore on 28th of August 2022. We have done submissions which were filed on the 30th of August 2022. That is when they were stamped. And we have also done a bundle of authorities as required. Now, having introduced the pleadings that we have filed, I wish to, looks like I don't have the petition, but basically the petition before the court, the petitioners are basically arguing for invalidation on the simple ground that there were so many violations of the constitutions and the electoral law by IEBC and its chairman, as the case may be, and as a result of which, those violations constitute such severe illegalities and irregularities that the results announced ought to be nullified. We have pointed out, for purposes of the specific issues raised by the court, we want to dwell with issues number 6 to 9 that were identified by the court. And to sum up, because before we go to the exact issues, is we shall basically be talking about 3 violations before we refer to the conclusion. Now, the first issue is the fact that over 700,000 people who ought to have voted during the general election held on 9th of August were deprived of the opportunity to do so. Number 2, we shall be arguing that the third respondent, that is the commission, contravened or violated its duty of accountability, transparency, and public participation during the 4 stages that we shall shortly be outlining, and in a manner that it declared the results of the presidential election. The third issue that we shall be referring to is the fact that the third and fourth respondents violated the procedure set out in Article 138 of the Constitution in discharging their mandate of tallying and verifying the vote at the Bomas of Kenya. I start with issue number 1. The constitutional basis for issue number 1 is Article 38 and 138A of the Constitution. And in this, we are referring to the number of people, 700,000 by our count, who ought to have voted and were deprived of the opportunity to vote. Now, what is a complaint? The complaint, members of the court, is laid out at paragraphs 56 to 60 of the petition, paragraphs 56 to 60 of the Constitution. And the supporting evidence is laid out in paragraphs 24 to 28 of the supporting affidavit sworn on 22nd of August 2022. The long and short of those paragraphs is that the petitioners are basically saying that by virtue of Article 1 of the Constitution, the people's sovereignty is exercised in Kenya by 2 major methods: through voting, and collectively we only exercise that right during a presidential elections. And number 2, by voting in a referendum. Now, under Article 38, it is expected that the right to vote for a candidate of your choice is recognized. The same way under Article 138(3)(a) of the Constitution, voting at a place appointed by the IEBC by all persons eligible to vote. Now, on that basis, Regulation 90 of the Elections General Regulations Act, General Regulations 2012, were done under the Elections Act. Regulations 90 provides, is a short provision that I need to read, that the Commission may make provisions for the voting by election officials, observers, patients admitted in hospital, older members of the societies, members of the defense and security forces on duty, prisoners and nomadic pastoralists, and other persons who by reasons of any special need, including disability, are unable to access a polling station. 2, the Commission may from time to time publish notices on the manner and procedure of the conduct of special voting, and such notices shall be read as part of these regulations. So the long and short of it, but I want to tie up with the facts. In paragraphs 50, the petitioner say no such notices were issued with regard to the persons in contentions in this particular contest. Who are those persons? Those persons include at least 500,000 elections officials. They include at least 180,000 members of the security forces. It includes those people who are in hospitals and others who may not be in hospital. But they are placed in such circumstances that special arrangements ought to have been done to ensure that they were able to exercise their rights under Article 1 and Article 38 of the Constitution. Now, why have we chosen the figure 700? The figure 700, as you will see from the affidavit, has been chosen for the simple reason that there should be no contentions about it. These figures, these are elections officials. The IBC chairman is quoted in the newspaper report that is attached to that affidavit, in fact confirming that indeed all these number of peoples will be engaged during the election day. Their engagement during the elections day follows up of necessity and in the nature of their duty that starts at earlier than 6 a.m. and ends long past the counting period, that those are the people envisaged under Regulation 90, that special arrangements to ensure that they vote would be made. It is not denied, in the face of how these complaints being made, that those arrangements, in fact, were not made by the Commission. Now, it is important to point out these regulations were made in the year 2012. Of course, it is interesting to know, faced by these complaints, how did Chebukati answer them? He answered them in his affidavit by first of all saying prisoners were allowed to vote under Regulations 90. He says diaspora Kenyans were allowed to vote under Regulation 90. And he also says very old people and sick people would be first on queue, and so such instructions were issued to ensure that those kind of people would vote first with a little bit more convenience than others. But, Your Lordships, it is important to note that when it comes, for example, that prisoners voted, prisoners have been voting in Kenya in the presidential elections, not so much because IEBC has been complying with the law, but because I believe it was Judge Lenaola, when he was at the High Court, made an order first that prisoners to vote in the presidential elections, and number 2 in the referendum. And that was done. Even the reasons why diaspora voters vote in Kenya is again because of another subsequent court decision. So that where we stand today, for purposes of Regulation 90, IEBC cannot give a single instance that in support of ensuring that as many Kenyans as possible will vote for the presidents of Kenya and exercise their rights to franchise has ever done anything. There is no evidence of that. Now, during the preparation of this petition and afterwards, for purposes of these kinds of violations of the right to franchise, it is a very serious thing across the world. Because as many of us are entitled, and that is why even this right was given to prisoners, to ensure that we vote. You find in very many other countries where elections have been nullified because of the issue of franchise. But you do not have a single instance, at least to the best of my knowledge, that this has ever happened in Kenya. And this could probably explain why, even after the Constitution is clear on this issue, that facilitations be made to ensure as many people as possible and those in special circumstances, those arrangements have never been done by IEBC. It is my submissions that given the results that were declared on the 15th of August this year, voting by up to 700,000 voters, even if that was adjusted, how many of them could have been registered and how many of them could actually have voted to the actual averages, you would still have arrived at a very big figure of more than 300,000. That directly and on account of non-compliance with an express provision of the law were unable to vote. Did the failure to make that accommodation, those arrangements to ensure those people voted affect the results of the elections? Undeniably. If those people had voted, it is our submissions that the results of the elections could have been affected. And my Lord, it's my submissions that unless and until this honorable court take up that issue as a serious issue of violations of constitutional law, then Regulation 90 could as well be an empty piece of legislation. And therefore, part of the enforcement of ensuring that the universality, that the free franchise and universality of it is respected, would be to ensure that a very serious elections was violated on its account. And it is on that reason that when we read our submissions, we are urging the court to do exactly that. Issue number 2 has got everything to do with the fact that the duty of accountability and verification, as we had said, was violated at various stages. It is my submissions that there are at least 4 stages in which this happened. Number 1, stage 1 ordinarily occurs the stage between 20th, the election period. A gazette notice was issued on 20th of January to signify the commencement of the election period. That period ended on the 8th of August. Then there is stage 2, voting day. Then there is stage 3, which is the 7 days period under the procedure set out under Article 138 of the Constitution. Stage 4, in my submission for purposes of the presidential election, it is the 21 days period under Article 40 of the Constitutions that you are dealing with right now. Now, what are the stages at stage 1? The issues at stage 1, and I will link them up with how they tie to the elections, is the fact that in this particular case, IEBC, according to my clients, was supposed to ensure that they set up a technology system that was transparent enough to ensure that the outcome would have credibility in the eyes of the electorate. The one single issue that we have pointed out for purposes of that in an elections where you've said you have recognized voters using KIMS kit, it has been recorded, it is our submissions, that on day 1, in their affidavit they say 6 hours, that at least 6 hours after the conclusions of voting, Kenyans ought to have known what many people voted electronically and using any other complementary system of voting. And my lords, it is my submission that the failure to do that, one cannot be able to speak of a technology that worked if the most important component that a voter ought to know, the right of a voter to know, yes, we voted. If we reach this number, this man is president. If we reach this number, this one is president, or is in the opposition. that number ought to have been given without any dispute. There should be no controversy about it. Yet the fact that you have all these controversies about the register just points out to the issue that on that critical element, there was serious failure of that technology. But it may not necessarily have to be a serious failure of the technology, in the sense that it could well be that the manner in which now you conclude voting, Forms 34A were uploaded, but the actual figures were being named on day 2. This is day 2 after the arrival of all Forms 34A. It is our submissions and my hypothesis that any person, and nowadays there are so many books that you can read anywhere and you can buy anywhere, that says how do you rig elections. If one was set out to rig an election such as this one, then one of the most important variable would be the voters register. And in this case, it is our submission that the fact that on day 1, 6 hours after the election, we were not told in a controversial manner, and after Kenyans have invested in a technology, that this number of people voted, this opened the system in the subsequent verification process to the kind of abuse that more other able people in that area have spoken about today. But that, on the face of it, appears to be where the opportunity arose. I go to the issue of still at stage 1, the issues of the nomination. We have said in our affidavit that for purposes of Article 99 of the Constitution, the presidential candidates were supposed to be subjected to qualifications under Article 99. The manner in which that was done for purposes of presidential election, the second respondent was actually not subjected to it, and at the end of the day, persons with unresolved questions under Chapter 6 is today Deputy-elect of the Republic of Kenya, arising out of the failure of IEBC to enforce the law. The next issue is the publication of a Gazette Notice number 9540 on 8th of August. This Gazette Notice in our submissions was an instrument of illegality. My learned colleague, Mr. Nyambodi, says that IBC chairman is always inclined to produce Gazette notices even where none is required. I read it differently. If you read Gazette notice as an instruction manual, it makes a lot of sense. In this sense, that in the ordinary scheme of things, and particularly when I was working in the human rights movement, when you deal with a lot of police officers and other people on those junior ranks, this activity will be carried this way. They'll not tell you the Penal Code says this, the Police Act says this. They will tell you the forces standing order, which they are socialized to understand, says this. So this was the forces standing orders. So that for purposes of the day when this verification was being carried out under this, what we are calling stage 2, it was being, and it was published on the eve of the election. There was also the bad faith that on the eve of the elections, you publish such kind of a Gazette notice that runs directly counter to the Constitution. Why would anybody do that in good faith? There was lack of good faith. Because in the Republic of Kenya, during my practice of a couple of years in public law, we are aware this is the kind of stuff that we present in constitutional division and the judicial review courts to confirm whether or not it complies with the constitutions or statute. Therefore, when you publish such a Gazette notice, an instruction manual that would be deployed during the verification exercise, and the following day is a public holiday, you cannot be taken to have been done that with the best of intentions. We go to stage 2, voting day. Voting day, the first violations that we talked about, not everybody entitled to vote under Article 138 in the presidential elections actually voted on account of non-compliance with the law by the IEBC. The second issue for purposes of that day, I've already talked about it, is the voters register. that on the elections day, and we have said 6 hours, you needed to know how many of us voted. The moment that information was not provided, the system and the process was exposed to anything could happen. And actually by the 15th of August, the worst, all that could go wrong actually went wrong on the 15th of August. And therefore, this is why we are saying these violations were not just minor violations. They were violations that indeed went into the heart of what is before this court, the disputed elections. At stage 3 is what we call the procedure under Article 138. Well, my constitutional law mentor, Dr. Gibson Kamau always used to tell me, and I believe most of the people who had the privilege to be his pupils, that the Constitution must be understood in a historical context. And therefore it is important that we understand Article 138 in a historical context. What is this context? This context, my lords, is this, that we do not have an equivalent of Article 138. We do 6 elections. The Constitution has not told you this is a procedure at the parliamentary elections or the governor or anybody else. It is only reserved for one position, the president position. The procedure at the presidential elections. And this was to leave no room of doubt that this is how in which the verification process ought to be carried about. My lords, the process after we vote in a presidential elections, I first voted in 1992. And since that year, the first multi-party elections, after voting, of course in Kenya they tell you, vote, go home, watch it on television. You will get to know the outcome. How it has always worked is that you are there at home, results are read from constituencies, from everywhere else across the country. It is a ritual that happens every year as far as I can remember since the year 1992. Now, what is the importance of this ritual? It is important to remember that in the year 2007, this ritual was disrupted by the events that happened at KICC. The disruptions of this ritual led to the post-elections violence, and the rest of it we are all aware what happened after that. So that it is not a simple ritual. And so that in the year 2010, when the Constitution was written, it provided for a sections and 7 days and a procedure, setting out in no uncertain terms, this is how after people vote for their president, we are going to process the issues. So that the Constitution having dealt with that issue against that historical background, you cannot have a situation where subversion through a gazette notice is tried to be effected. That would be treason in every sense of the word. I go to the issue of what's the importance of the ritual. To the winner of an election, this ritual that we saw in this constituency, what you got in my neighborhood, is very important. Because the people, while we are seeing all this being displayed, and remember that during bombers, the display to show Kenyans that these are the results that were coming in, this is how the figures were adding up, that was disabled at some stage. So that what effectively this meant, that the true purpose of Article 138 ends up being defeated. Defeated in the sense that for the winner goes and declares that I had the most numbers in accordance to Chebukati. And the loser, everybody else says, I do not know how you got those numbers. I actually thought I had more than you had. This is what was tried to be prevented. But it is equally important, the procedure under Article 138 for the loser. Why is it important for the loser? Because the loser, and in this case the loser is a loser with say about 6.9 million votes, quite a number of Kenyans. This is a loser on his 5th time seeking the presidency. The last one he says he lost under controversial circumstances. there was everything necessary to ensure that for purposes of these elections, if you are to lose the election, the math must make sense. It must add up. The Kenyans, those people who voted for you, must also see that you did not do very well, because it is clear these people in that other place did not vote for you as you expected. Now, but when you have now a true situation on the 15th, the dramatic events of the 15th of August, where even 27th constituency, my clients are there waiting at home. I was also equally waiting at home. Those results are not announced. Then how do the people who are supposed to be losers understand that they genuinely lost in the elections? That would strip the process of legitimacy. But it is equally important for another reason that Wallace Soyinka talks about in one of his essays. And I believe the essay is published in a book called Climate of Fear. And Wallace Soyinka, in an essay titled The Quest for Human Dignity, says that in war, it is important that those who lose a war should not be stripped of their dignity. And basically what this means is this, that even after losing war, you are not stripped naked, in the sense that you are told you lost half of your country, but you must be left with the other half. That is if you are in the Russia-Ukrainian kind of situation. That is a whole idea that nobody should lose absolutely. And when the Constitution talks about fairness, about transparency, it is to enable that this is processed in a manner that everybody else would be able to understand and to process the victory or to process the loss, if it turns out that it was a loss. Now, we go to the issue number 4. I wish I could say more. I'm just trying to watch myself. Stage number 4, the final issue is the Supreme Court issue. We served Chebukati with our affidavits. And I would not say he's arrogant, because that may not be a permitted language. But the language that he used is one that shows lack of remorse. You will read the affidavits. On the issue of, why didn't you make arrangements for everybody to vote? We were talking about specific people, election officials. Then he says, oh, prisoners voted, diaspora's people voted, and all these other people voted. Now, that was not the issue. I think they are needed, and this is accountability to the Supreme Court. And that is the design of the Constitution. That now that a violation has been committed, what do you have to tell the court about it? You could not even say it was an oversight. The next one I will recommend to the next chair to ensure it is done. There was no such thing. Then we go to the next issue. In our affidavit, the third petitioner says, I was disturbed about the events of 15th because in the morning of 15th at around 7:30 a.m., I was shown some text that seemed to show the results that now are being announced later. Why was it disturbed? Because at that time, votes were still being counted. People are being told in constituency A, this is what people got. How does Chebukati react to that? Or everybody with a good calculator could have downloaded these forms 34A and calculated. Now, Kenya is a country with extremely low digital literacy. To say, and when such a thing that would cause concern, that there was a problem, and you say this information was readily available, leaves a lot to be desired on the part of a public officer. I start with finishing with the issue of legitimacy. It is important that winners should have legitimacy. And it is also important that the losers also should be treated with dignity. When we read the affidavit of Honorable William Ruto, he says, oh, so many people, why are you pretending that you are acting for all Kenyans? So many people agree with my victory. But it is also equally true, so many other Kenyans don't agree with it. And therefore, in a constitutional democracy, as I conclude, it is absolutely important that when you win, and Article 38 says you win it this way, it must be confirmed. Thank you very much.
Thank you very much, Council. We would like to take the submissions by, I think, 4 respondents who are supporting the petition. That is the 4 commissioners. According to the time schedule we allocated yesterday, they were to share the 1 hour. But before Council, you take the podium, we are proposing just a 15 minutes health break. Then we come back because we will hear those submissions, and if there are questions from the bench to all the submissions that have been made, they will be directed to Council. So we'll need about 1.5 hours when we return to finish today's proceedings.
Taya, on the word from Justice Lenola, could the court find out what's happening to the question of scrutiny? Because it looks like we still have a crisis.
Yes, we shall. I'm aware.
KTN News. Get the whole story. Standard Group's Farm Kenya initiative is the umbrella entity for all agriculture-related channels, activities and investments. The media platforms under the Farm Kenya initiative include the Smart Harvest Weekly Pullout in the Saturday Standard, KTN Farmers TV, a 24-hour agribusiness TV station.
We've come to the end of AgriTalk.
Thank you so much for keeping it here.
Maisha Kilimo, a weekly agriculture show on Radio Maisha. AgriTalk on Spice FM's morning show The Situation Room, and Grind na Agribiz on Vibes Radio morning show Morning Vibes. Find us online at www.farmers.co.ke, an integrated website that creates and aggregates agri-content, hosts a digital marketplace and wide range of agri-data. Other platforms include specialized events such as the annual Mkulima Expo, quarterly Farmers Kenya Breakfast, and dedicated social media platforms at Farm Kenya 254. Farm Kenya, working to secure your growth.
Nimeongea pia na ma-MCA wangu na mimi, na tunajua kile kitu cha muhimu kwanza kuanzisha ni kuhakikisha hospitali yote yako na madawa, na tutahakikisha hiyo imefanyika. Kwa hivyo sasa kazi imeanza, kampeni zimeisha, tuingie kazi na tufanye kazi.
Oh, it's brilliant from Mo Salah, and still Salah. Oh, sensational!
Naam!
Masaa ni sasa. Formation imekubalika. Radio Maisha, Spice FM, Vibes Radio na Berur FM wakuletea the best of the 2022-2023 EPL season.
Sit up nicely.
Usikose kujiunga nasi kila wiki for the best of the Premier League. Yani the full 90 plus all the extra. Ujumbe huu umeletwa kwako na The Standard Group PLC in partnership with the English Press.
So what happens when a pet lover wants to travel and cannot bring along the pet?
Always try to think outside the box.
Niliambiwa kama unaweza songa ukiwa mwanaume utafaulu kwa maisha.
Ukiona kitu maybe kwa TV, maybe ka art form mpya, anza kudo research kivyangu.
You looking for employment and are tired of sending job applications without any response? Gone with no response? Tarmacking is now a thing of the past thanks to Skiza. Dial *811 *1 *21 hash and subscribe to a ringback tune that reflects your qualifications only for 1.5 bob a day. And your callers will know your credentials and send you opportunities they come across. Set the tone with Skiza. This month's issue of Planet Action magazine. Illegal sand harvesting in Makwini becomes rampant as some students boycott school to make quick money. Physics teachers' passion from childhood turns trash into treasure by creating renewable energy. And how plans by East Africa Crude Oil Pipeline to construct heated pipelines to affect an estimated 40 million people. To get more stories on climate change and wildlife conservancy, get your copy of Planet Action by visiting epaper.standardmedia.co.ke. Planet Action, creating awareness and impact. Spread it. This is a public service announcement brought to you by KTN. KTN, welcome home. KTN News. Get the whole story. Future Makers by Standard Chartered is a global initiative to tackle inequality by supporting young people to learn, earn, and grow. Since launch, Future Makers has reached more than 671,000 young people through programs such as the Women in Technology.
Lugeshara is a language development center that focuses on tackling language deprivation in deaf children. These are the early years. So we focus mainly on early detection and intervention. What is that? That means providing information around early childhood deafness and its implications towards a child if that is not corrected. So what happens is when a child is born deaf, rarely do parents get to know that the child is deaf, and most of the time it's the mother who gets to know, and when they know, they also take probably averagely 2 years to do something about it, whereas at the same time, the deaf child needs language stimulation, and language stimulation is where a child is exposed to language meaningfully and regularly within the language development here. So what this does to the child when they are not meaningfully exposed to language is there's a part of the brain that shrinks, the language component, which is irreversible. So then the parents get to do something about it when it's late, when there's really nothing they can do about it. That's what is language deprivation. We use a user-centered design innovation model to speak to our product development. This is following the user pain points to create products. And we also use technology to facilitate access to child-friendly Kenyan Sign Language through a learning management platform that is customized for deaf children. The Standard Chartered program was really helpful for us, and at that time, there were barely no accelerator incubation programs for disability-focused founders. So that was a great plus for us that we were part of the training program. And then the second thing is that the mentorship and coaching was really helpful in product development. So that's why we're able to learn around user-centered design, and that's what has allowed us to have all the different products that are now market ready. And the third thing is that we got a grant of 10,000 USD, and that's really was helpful now in actualizing the product development into real products. And that's what has now enabled us to go to the next level, which now is scaling the product.
All funds generated from the Standard Chartered Nairobi Marathon go towards supporting the Future Makers programs like Lugha Ishara.
Yes, I'll be joining the Standard Chartered Marathon this year. I'm very excited. Please join me in October, and let's help other future makers to impact the world.
Register today at www.nairobimarathon.com.
You made me so proud today. I'll never forget the day you got accepted. Remember how you just jumped in right away and gave it everything? It was so inspiring, especially for your little brother. And now I can watch him follow his dreams.
KTN News. Get the whole story.
Definitely a very packed day today here at the Supreme Court, the Milimani Law Courts, where we've seen about 8 hours of straight law and jargon about the case that is before the Supreme Court, the 7-judge bench that has already just gone for a health break for about 15 minutes before we resume with 4 other petitioners who are or 4 other respondents in this case, the 4 commissioners that dissented in the case that is currently before the court. And of course, you're going to speak to some of the lawyers who are here. They're currently outside waiting to be called back, but we'll not go into the details of the case or the merits, as the lawyers say. It will be sub judice to go into those details, but we've seen so much. We've seen some legal terms, amiable compositor. I have Professor Tomo Jenda, Senior Counsel, who is also representing this case, the Azimio side, if I could say that, in this matter. So, Prof, we've seen a very heated day today. What do you make of what we've seen so far?
I think we are going on well. The Supreme Court has had all the petitioners, and now we're going back for the 4 commissioners to submit through their counsel. And I think it's instructive to note that it's been a long day for us. We have gone through the submissions, and we're happy with the way it is going because the court is composed. The court has given us an opportunity to address it, and we have addressed all the issues that inform the petition, the violations and all. I think we're happy with the way it's going.
Okay. We are coming back with the 4 commissioners who have been given 1 hour to make their case. And they look like they're also petitioners, but they're respondents in this matter. What do you make of such as we go into it?
I think the court has made the determination based on the affidavits that they have filed. And I think the affidavits largely support the petition. And if they support the petition, then clearly they then would be petitioners because they agree with the petition and would want the election nullified.
And according to what you've already presented, you've had all the time today. Do you think you've already made the case to ensure that the presidential election is nullified and you go back to the ballot?
I said in my submissions that the Latin maxim of ex equo et bono, always applied by international tribunals, will be very useful here. That the court will look at what is justice and what is just. And that is what the amiable compositeur principle entails in French law. Basically, the court looks at what is right in lex arbitrae and makes a decision. I think we're doing well.
All right. And maybe before I let you go, perhaps going into the next 1 hour and then we'll be breaking for tomorrow, do you think the time that you've been given today has been enough for you to make your case?
The time has been sufficient because we have had many petitioners submit and we are happy with the Supreme Court. And tomorrow, I think we start the respondent's case. We're going back for the completion of the petitioner's case. And I think we're happy about, happy with the way it is proceeding because every petition has a perspective. It's good, and I'm sure the court will have sufficient material on which to make a decision.
Thank you so much.
Thank you very much.
Senior Counsel Tom Ojenda, professor who is also Azimio or an advocate of this court, of course, is trying to make his case for what we expect today. So much of legal jargon, French law, and of course Latin, so much going around here. And let me now engage some of the other lawyers who are here. Let's just start with introductions for Kenyans to know you and tell us who you're representing today.
My name is Kenneth Amondi. I am an advocate representing Professor Wajakoya, who was an interested party, and of course also in support of nullification of the election petition. So it is on that basis that I am present today in court. Yes.
All right. And so far you think everything is going on well because your client yesterday was not accorded the audience that he requested for?
Yeah, of course, we believe everything is going on well, in as much as, like we did indicate yesterday, we felt the decision was not proper. But as I always say, we abide by the decision of the court. But of course, insofar as today's proceedings are concerned, we saw the petitioners, and there were various, around 7, setting out their case. They were well grounded and set. More or less, the arguments that they had are the same that my client also presented, in terms of the fact that there were numerous, irregularities, and they were such that, the only result that could issue is that of a nullification of the election. I want to honestly believe that that has been properly set in the petitions that were presented today, starting with, the counsels by the main petitioner, and also the counsels in respect of the, subsequent 6 other petitioners.
Thank you so much. Thank you. That's one of the lawyers. And of course, there was an issue about the servers, the IBC servers, and the IBC, according to Azimio lawyers, and that is James Orengo, senior counsel, mentioned that they were not given access to 7 out of the 8 servers by the IBC that the court had said that they should be given access to. And the person who raised that alarm should be James Orengo, who's just behind me right now, trying to, of course, converse with Paul Mwangi, one of the lawyers as well for the Azimio team of Martha Karua and Raila Odinga, and we hope that we might be able to talk to him in a minute, but there's been so much activity running around here as we try to circumvent and of course just go into the details of this case that is there to try and of course try and change the ruling that was given or the certificate that was given to President-elect William Samoei Ruto as the 5th President of the Republic of Kenya. And we've seen about